Proszę Państwa, nazywam się... My name is Christian Markiewicz. I'm president of the Polish Judges Association Justitia and chair of the Interdisciplinary Center for Research on the Judiciary of the University of Silesia. It is my pleasure to welcome you here to the University of Warsaw, of which I am not an employee. However, Karol Weitz, a friend of mine who was to be with us today, and unfortunately, due to his health condition, unexpectedly had to excuse himself, and he sends his greetings. However, on his behalf and mine, welcome. Welcome to everyone present here today in the room and those joining online. We have a very distinguished group of participants from Poland and across Europe. Monica will correct me if I'm wrong, and so will Maria Rosaria, who is with us. We have representatives of a range of associations and organizations from many different countries. And most importantly, however, the idea for this conference came from the Association of Judges and Prosecutors MEDEL. We have the honor of hosting the president and the deputy president of MEDEL. Welcome.
Proszę Państwa, witam.
Welcome to our colleagues and friends from the European Network of Councils for the Judiciary, ENCJ, which was established way back with the participation of the then Polish Council for the Judiciary. Unfortunately, today the Polish Council for the Judiciary is no longer a member of the ENCJ. We are very sorry for this, and we are hoping this will change. We also have joining us online the president of the ENCJ, Daria Wasser-Riene. We have also former presidents, Professor Kes Sterk, our friend who has always been with us. We can always count on you. Welcome. We also have online the former presidents and a current member of the Spanish National Council for the Judiciary, Nuria Diaz-Abad. We are very happy to have you, as we have fond memories of our close collaboration with Nuria. I also welcome our guests from Poland, judges, the president of the Supreme Court, Dr. Michał Laskowski, former president of the Supreme Court, Dariusz Zawistowski, president of the National Bar Association, Mr. Puścik, former deputy ombudsperson, Dr. Hanna Machińska, welcome to everyone. I have to stop here as Monica will welcome some of our other guests. That's what we have agreed upon. Now, the topic of this meeting is very special, and it comes as no coincidence. We have decided it is high time to recapitulate some of the debates that have been going on with a focus on the right to a fair trial As the host of this event, Poland has been picked on purpose. We all know that for a number of years now, we have experienced massive assaults on freedoms and liberties in Poland, the independence of the judiciary included. Luckily enough, as a rule, we still have free universities in Poland. As a rule, we still have free courts and independent judges as a rule. Best proof is that we are meeting here today at the University of Warsaw, meeting here as Polish and European judges. We are here to talk about the primary and fundamental part of the right to a fair trial, the tribunal established by law. This is the starting point for any debates on the right to a fair trial. This debate has unfortunately has been forgotten in Europe for many years with dire consequences we are feeling now. But I'm sure that we will not only better understand the criteria of the tribunal established by law, but equally importantly, as Professor Sterk has noted in his address a month ago at Maastricht, we will also consider how to ensure that those criteria are met. What should be done that a tribunal established by law not only operates in academic debates amongst judges, but that both in European Union, in Europe, where Article 6 of the European Convention applies, we can effectively ensure that tribunals are indeed established by law, because that is a right of every person, every individual, to be judged by a tribunal established by law, to have their case considered by a tribunal established by law. This is why we are meeting here today. So now, without further ado, I invite my colleague, President of the Medal Association, over to you.
President Markiewicz, dear colleagues, on behalf of MEDEL, I wish to thank the University of Warsaw and Justitia for making this event possible. It is really an honor to be here together with so many distinguished speakers to whom we address our warmest thanks for accepting our invitation. For MEDEL, being here today means to reiterate its commitment for democracy, fundamental rights, independent judiciary, and pay respect to the example of bold and steadfast commitment for the defense of the rule of law. From here, from our colleagues, we had a courageous demonstration of what does mean to be European judges and prosecutors and feel as such to be part as a community founded on the values drawn in our fundamental charters. It is through the Polish lesson that we understood what does mean to be not only independent, but also fully aware that judicial independence is not a personal privilege, but the essential tool for the protection of the equality of citizens before the law. It is from here that comes the clear demonstration that the future of democracy in Europe depends on the ability of its demos to defend our values from the attacks brought by a process of manipulation of judicial systems, which is part of a broader process of democratic backsliding that eventually means reducing the realm of rights and freedoms of citizens. The experience of Turkey, of Murat Aslan, of all our Turkish colleagues, judges, prosecutors, lawyers, dismissed, arrest, teaches us all this the hard way. This is our court, said the board displayed on the Supreme Court's wall during the Solidarity Chain of Light protest event in July 2017. While looking at this event, we had a demonstration that a broad front must and can be built for the defense of the rule of law, encompassing academy, civil society, free press. We could see how the solidarity expressed by the judiciaries from all over Europe can generate a strong call to the European institutions to consistently pursue the defense of the very future of democracy. Right to independence, right to Europe. This is the message that came from this town and the March of 1,000 Robes. With this extraordinary event, it became clear that the rule of law and fundamental rights guaranteed by independent courts are the essence of our common identity. It became clear that the path we, judges and prosecutors, sharing this identity, have taken towards the realization of a common area of justice is one with no return. From here today, we can most clearly listen the tragic and deadly noises of a devastating war. We want to renew our support and solidarity for the tragedy that the people of Ukraine are suffering. Such a violent disruption of the fabric of international legality calls us to support the resilience of the judicial system and to urge the support of the international community so that justice can continue to perform its essential function to protect human rights. It will be indeed also through justice that the conditions for a free and peaceful existence for the Ukrainian people can be rebuilt. Today, we will discuss on a crucial topic, judicial appointment procedure, the European common standards, how can we have back in place one of the most important tenets of the rule of law as the independence of the courts when the structural guarantee of independence is compromised by deliberate breach of the procedures governing the court's composition. The choice made by our constitutions and fundamental charters that expressly provided for the right of each person to be judged by a tribunal established by law was definitely visionary one. This expression encapsulates the guarantee of the effective judicial protection of rights from any arbitrary exercise of authority. This principle is a prius, even with respect to the independence and impartiality of judges, a self-standing right, the cornerstone of a right to a fair trial, as the European courts clearly asserted. And our conference today will examine all the implications of this principle, not only the prohibition of on the establishment of ad hoc tribunals, the necessary independence of the selection body to avoid interference by the executive, but also the guarantee of the quality of judicial appointments and the guarantee against the risks of arbitrary decision-making within the machinery of justice. The right to a tribunal established by law has emerged from the cone of shadow cast by the other two components, impartiality and independence, following the frequent cases of arbitrary and targeted manipulation of judicial institutions. It is no longer just, it is no longer just a problem of disrespect for rules and standards. It is a problem of irregular procedure intentionally implemented by the executive to subvert the judiciary from within. It is a problem of an unprecedented strategy represented by the establishment of courts and judges only apparently established by law, masquerading tribunals, new star chambers, as in the words of Laurent Pech. European courts repeatedly highlighted the violation in Poland of the right to an independent court established by law. The report in November 2022 of the Secretary General of the Council of Europe on the consequences of the decision of the Polish Constitutional Court stating the unconstitutionality of Article 6 of the European Convention of Human Rights stressed that the obligation of Poland to ensure to everyone under its jurisdiction the enjoyment of the right to a fair trial by an independent and impartial tribunal established by law is not fulfilled. The role played by the Polish Constitutional Court, which has been in its turn considered in 2021 by the European Court of Human Rights in a composition established in violation of Article 6, created an institutional short circuit that can entail consequences on the whole structure of the European Union and on the framework of the basic European consent on fundamental principles. With a clear risk, the aspiration of creating an ever closer union among the peoples of Europe is destined to collapse if legal black holes begin to appear on the judicial map of Europe, as in the words of the Advocate General Bobek. All this is what is at stake in a process, replicable and no longer circumscribed within the Union, that leads to an erosion from within of the independence and legitimacy of judicial systems. The challenge that awaits us as jurists is to confront the full implications of this process as a part of the more general phenomenon of democratic regression that operates by hollowing out democratic institutions from within. The challenge that awaits us as judicial associations is to continue along the path we have taken of the common commitment to the rule of law and to support judges and prosecutors who are working to safeguard the basis of the European community. And the challenge that awaits us as citizens is, in spite of everything, to continue to be ambitious when we talk about the rule of law. And as Commissioner Reding said when presenting the new rule of law mechanism in 2014, to ask Europe to be ambitious, at least as ambitious as it has been in putting in place common fiscal rules and banking union. Thank you for your attention.
My name is Monika Frąckowiak. I am a vice president of MEDEL and also a member of Justitia. Thank you for coming here, for participating in our conference. I wasn't supposed to take a floor, so nothing is prepared from my side, but deeply from my heart. Thank you again, and I would like to especially warmly welcome the strong representation of European Association of Judges, which is our big friend in our fight for rule of law, and the President, Mr. Duro Sessa. And Vice President of Association, Mikael Sjoberg from Denmark. And we are also honored to guest representation from Ukraine, Mr. Lev Kishakiewicz from the Supreme Court, the Criminal Chamber, and the member of the Ethical Council of Judges, and Olena Żurawska from Ukraine. We should start the panel in a few minutes, so I will not take the floor any longer. Thank you again, and please, the panelists, we can start the panel.
I would like to welcome. Use it? Okay. I would like to welcome our panelists. We will have a connection online with Dalia Vassiliena. She's president of European network of councils for judiciary. We also have in here Mr. Durosesa, the president of European Association of Judges, Professor Kees Stek, professor of law on Maastricht University and former president of European network of councils for judiciary, and also Professor Christian Markiewicz, president of Justitia and professor of Faculty of Law on Śląski University in Katowice. I guess Madam Dalia was the first one to...
Yes, there is online connection already.
Okay, so we have to wait a moment for connection.
Hello, everybody. Can you hear me? Hello?
Okay.
Can you hear me?
We cannot hear.
You can hear me? I'm sorry. I'm not sure,
Hello.
but hello. Can you hear me? Is it a correct? Is it connection with the conference?
Okay, now we can hear you.
Yeah, okay, wonderful. So probably I will share the slides.
Okay.
I will try to share the slides at first. And then I will start presentation. Can you see the slides? Can you see the slides I'm trying to share? Okay. Is it some problems with the connection? Can you hear me?
Yeah, we can hear you. Yes.
Can you hear me?
Yes, definitely. You may start your presentation.
Yes. Okay. And can you see the slides I'm trying to share?
Not yet.
And now?
Perfect.
Wonderful. Thank you very much. So, dear colleagues, dear friends, dear judges of European Union, dear friends, and dear all. Today we are here to speak and to discuss about one of the backbones of the democratic society, independent and impartial tribunal. Are all aware that it is a fundamental right to have one's case heard before the independent and impartial tribunal. It is a right that is established in the Article 6 of the European Convention of Human Rights, and it is also enshrined in the fundamental documents of the European Union. The Article 2 of Treaty of the European Union knows that the Union is founded, among other values, on the rule of law, which is a value common to the member states. This provision, read together with the second subparagraph, Article 19(1), that member states shall provide remedies sufficient to ensure effective legal protection in the fields covered by Union law, is also a guarantee of independent and impartial tribunal. The same guarantee is enshrined in the Article 47, paragraph 2 of the Charter of Fundamental Rights of the European Union. And even though everyone here is aware of it, I would still like to start this presentation by noting the rather obvious and independent and impartial tribunal established by law is the guarantor of the rule of law and the cornerstone of democracy. And one of the key elements of such tribunal is appointment of judges, which is the topic of the conference today. I have an honor and the privilege to speak the first today. In my presentation, I will attempt to give a brief overview of European and probably a bit international standards of the appointment of judges. I hope that this will set a scene for the other speakers and perhaps give ground for further discussion. I would like to start my presentation by saying that a number of international organizations and institutions have looked into the matter of judicial appointments. I hereby provide several documents on which I base my presentation today. These are key recommendations on judicial in Eastern Europe, South Caucasus, and Central Asia. Compilation of Venice Commission options and reports concerning courts and judges, research papers, the ENCJ standards and works. As you can see, this is also a topic which brings together the institutions representing society, judiciary, and scholars. I'm here today representing the ENCJ. I would like to stress that it is an exceptional organization in this realm which works on the topics of independence, accountability, and quality of the judicial continuously. It is done through a continuous peer-to-peer work in developing indicators and tools which give a possibility for the judiciaries to evaluate themselves and seek better their independence and accountability. The following documents and activities relevant to the topic of today's conference are undertaken in this regard. Minimal judicial standards were developed. The working group develops indicators and tools that would allow the judiciaries to measure their independence, accountability, and quality. This activity follows a precise and continuous circle which allows to improve independence and quality of the judiciary. Some of those tools are questionnaires on independence and accountability of the judiciary and on quality of the judiciary. Furthermore, a survey among judges is carried out to see perception of judges on their independence. It is done repeatedly, therefore allows to see whether there are changes on the independence of the perception of judges in a given jurisdiction. In 2022, the survey was carried out for the fourth time with almost 16,000 judges participating. Speaking of the European standards on the appointment of judges, I will briefly address the following subtopics: legislative instruments, appointing authorities, and selection of judges. and candidates also. The fundamental principles ensuring judicial independence established in international and EU documents, which I have already mentioned before. In order for a tribunal to be established by law, the main principles have to be properly established in the law. The European standards would therefore be enhanced to if the main principles of the appointment procedures would be set out in the Constitution, main actors in appointment and procedures set out in the primary legislation. The rest can be detailed in the bylaws and independent judicial authority. As the appointing authorities are regarded, an independent judicial authority should play a significant role in appointment procedures. The underlying condition here is that such an authority itself should be independent. In the ENCJ Compendium on Councils for the Judiciary, the ENCJ has developed standards to which such an independent judicial authority should adhere. At least the following core standards should be mentioned here. It has to be comprised fully or in a large part from judiciary. The majority of members should be judges elected by their peers. The ex officio judicial members should not be seen as being part of the majority chosen by their peers. Widest possible representation among the courts, instances, levels, and regions, as well as diversity of gender should be ensured. The authority should have broad powers to promote judicial independence and accountability. Of course, have a fixed term mandate. The same guarantees as judges should be provided for the members of this authority, should manage its own budget, independent from the executive, and should possess a legal personality. The European standards provide that first, such an authority has to be independent, and secondly, is comprised by majority of judges elected by their peers. The majority of judges elected by their peers is indeed one of the guarantees of the independence of such an authority. The ENCJ has adopted a compendium on judicial councils, which provide the ENCJ standards on judicial councils, and I will just mention several here. From the ENCJ, it is seen that the most successful models appear to be those with representation from a combination of judges elected by their peers and members elected or appointed from the rank of legal, academic, or civil society, with broad powers sufficient to promote both judicial independence and accountability. What does playing a significant role in the appointment of judges by an independent judicial authority means? In accordance with the European standards, it means that such an authority appoints or promotes to a higher instance court judges by itself, meaning that it takes a final decision, or in case that it is not a final appointing authority under the law, the advice of an independent judicial authority to an appointing authority is of a mandatory nature, or that such an advice is always followed in practice. Procedures followed by an independent authority should be transparent, and the reason for the decisions made should be given. The final remark I would like to share related to the appointing authority is involvement of political actors in the process. It is clear that it is endangering models where the executive branch of the government has a strong influence on the judicial appointments may work well in older democracies. This is because it is restrained by legal culture and traditions. From the perspective of the European standards, appointment of all tiers of judges by the executive, president of the state or monarch, and even more by legislative power, parliament or specific body, the reign of government is viewed as problematic. The fundamental question is, in such cases, is, however, to what extent an appointing authority is free to decide on the appointment. The European standards suggest that it should be merely ceremonial. And the last subtopic that I would like to briefly touch upon here, and which I believe cannot be viewed separately from the judicial appointments, is selection of judges and European practices therein. Furthermore, there also are requirements for the appointment procedures as well. It should be clear, transparent, and foreseeable. All these processes, stages of the procedures, and grading known beforehand to the candidates, and in fact should be made public. List of successful candidates should be made available to the public also, and a possibility to the contest results before the court or independent authority should be ensured. There are all the things I wanted to briefly share with you today. I hope some of these aspects that I have mentioned will be further developed by the other speakers, and that we can have an interesting and fruitful discussion on them. Thank you very much.
Thank you very much, Daria, for your interesting presentation and for being very disciplined about the time. Thank you. Of course, we cannot go deep into details, but for our panel, it will be precious to consider if there is one general model of appointment of judges in Europe or not. If not, can we point out any elements in the process of appointment of judges which might be considered as common in different European models of appointing of judges? And if so, what are the elements? These are the questions that I addressed to Mr. Kees Sterk. 15? Even 20.
Okay. No, it was a joke. Well, thank you for inviting me here. I'd like to thank Medel and Justitia for having this conference. I also want to point out, 10 years ago, would Justitia or the European Judges Association and MEDEL, would they organize together such a conference? I think, I'm not sure, but I think the answer would be no. And now these organizations are not competing, but they are working together for a common goal. And that is, I think, very important. And I like to stress this at this moment, that it is a very good, in my view, a very good thing to do. And if it was up to me, there would be even more cooperation between the organizations. That's my first point. Is there a general model of appointments in Europe? First, I want to say that independence and impartiality is the law. It is not soft law, it is hard law. It is in the treaties, it is in the jurisprudence of the courts of Luxembourg and of Strasbourg. And because it is the law, it should be enforced. Law should be enforced. It is not a matter for negotiations by politicians. It is a requirement of law. I think that is important. Another thing I want to point out before I go into the questions is that as to the result of independence and impartiality, it is more or less clear what independence entails, what impartiality entails. I fully agree with Laurent Pech in this respect. So again, there's no room for politicians to negotiate all kinds of things. The second thing I want to say before I go into the question is that, yes, rules are important, models are important, but culture is as important as rules and models. I will give you an example. I'm at the moment performing a review on the Bosnian Council for the Judiciary. We do this with colleagues from Norway, Finland, and Belgium. And if you look at the rules, the law on the HEPC in Bosnia, I think I cannot find one article in the law that is against European standards. Not one. However, things are not working as they should there. Perhaps the President Sousa knows a little bit more than I about it, but I dare to say this, that there are some major problems. So I would say culture eats rules for breakfast. Culture is as important as rules. So now I go to the answering of the questions. Is there a general model of appointments in Europe? No, there is not. Is that a problem? No, it is not. Provided that the models identify independent and impartial judges as required by the law. You can do it on very different ways. It's not a problem, not at all. Having said that, are there some common elements, requirements in European law? I think there are. Not only in the standards, which I see as a kind of soft law, but also in the hard law, in the judgments of the courts in Luxembourg and in Strasbourg. The first common element is there must be objective criteria. This seems very obvious, but it is not, because there are a lot of criteria in Europe on selection which have a huge subjective element to it. And it is these subjective elements in it that makes it vulnerable for political influence. So objectivity is very important. If you look at the case, the Iceland case of the appointments of the Court of Appeal judges there, it is objectivity. That is what the court in Strasbourg stresses. Objectivity, objectivity in very many respects. And if you look at the criteria, it must be merit, moral integrity, and courage, I would say, or technical competence to defend the rule of law. This is, I think, important. You see this again in the Iceland case of 2020. And another important issue is that the higher the position in the judicial hierarchy, the more demanding the applicable criteria should be. Well, if you look at the practice in some countries in Europe, it's just the other way around. The higher the position in the hierarchy, the more subjectivity, the more political influence there is. And the courts say, no, it should be the other way around. I think that is hard law. It's not soft law. It is hard law. Yes, of course, there is a problem about what should the content of the rest of these objective criteria be, because there is not, in my view, there's not a common definition or view on what should be the role in society. Some say, is this just a job applying rules? So then technical competence is the most important and sometimes the only important issue. Some countries say there must be a public function, meaning a judge should also defend the fundamental rights of the citizens. If you stress that, you need some other competences for a judge than just being a good technical judge. And there is a third group of countries saying that it is important that a judge provides service to the public. Usually in those ideas, efficiency of applying the law is important as well. And I don't think there will be, within 5 or 10 years, a lot of agreement on these different rules in Europe. Is that a problem? No, it is not. Because societies are different and the needs of society are different. But whatever role is important in the society, there should be objective criteria. That is, I think, of the essence. Then I come to the selection bodies. I use the word selection bodies, not councils for the judiciary, because if you look at Europe, there are many different kinds of selection bodies. Sometimes it's councils, sometimes it's judicial appointment committees, sometimes it's ad hoc judicial appointments committees. The rules about all these committees and councils differ very much. But that is also not of the essence. The essence is that there should be a selection body and that there should be judges in it and they should be appointed by the judiciary and they should have a majority. I think we can say that this is not just a standard anymore. It is, in my view, it is a hard law. So that is what I feel about this. And why is it hard law? It derives, I think, from the 3 Polish cases in Strasbourg about the KRS. There should be independence from the executive and the legislative. That is in these 3 more or less identical cases what can be learned. So I feel that if you look at all the selection bodies in Europe, you see that many countries, Luxembourg is one, Luxembourg is at the moment is changing the constitution. Czechia has changed its rules. If you look at all the countries through all the different ways of selection of selection bodies, there is this, I would say, common constitutional tradition in the make. Why is this important? If you look at the 3 cases about the KRS in Strasbourg, they are not saying because the judges were selected and appointed by Parliament, they are not independent. No, this is just one of the factors. There are more factors. What I here are saying is that we are moving to a constitutional tradition in Europe based on what is happening, what are the rules in by far the majority of the countries, that it is against this common constitutional tradition to have a selection body, call it council, call it appointments committee. It is against the constitutional tradition to have a selection body with judges in it, selected and appointed by Parliament. That means that you can have a totally different kind of procedures before Luxembourg and Strasbourg. And I think that would be very helpful, because the court in Strasbourg doesn't need to look at whether there is actual dependence, but you just have to look at how are the judges in the selection body, are they selected. That means that if you look at Europe, there are only, I think, 2 countries where Parliament selects and appoints the judges in the selection body, and they will have to change their law, because I feel that it will not take many years anymore before this tradition will be established, and Spain and Poland will have to amend the law. Okay. Then another common element, appointments by the executive. You see that at the moment that the hard law is, the judgment of Strasbourg is that, yes, it is not, well, it is not, no, let me put it this, that it is not forbidden to have the executive appoint judges. But you also see in the hard law, in the cases of Strasbourg, that this is not an unlimited power. You see also in the judgments of Luxembourg. For instance, you have the Malta case, where the court expressly said that it was important how the executive uses this power of appointment. And if it's used just if they do not follow the recommended the candidates, if they do it on a regular basis or in just exceptional circumstances, the court seems to say that in exceptional circumstances, it can be justified, but if you use it on a regular basis, it is not. That is 2021. But I think what is more important is the Iceland case again from 2020, I think, where they are saying that, yes, the minister does not have a duty to follow the requirements of the selection body, but if they do not follow, it must be for a reason that is highly objective, so not subjective, not political, and the high level of reasoning must not allow or to endanger the objectivity of the selection process. This is a very high level of reasoning. And if you read the Iceland case very carefully, you see that here the court in Strasbourg, in my view, is not explaining how the Icelandic law is working. No, they are explaining what the content of the convention is. So this is, I think, a very important important case for the appointments, the appointment process. I was also asked to say something about, are councils for the judiciary necessary? You know, this probably as a former president of the NCJ, you probably will say that I will say that the answer must be yes. But as follows from what I said before, you can have a council for the judiciary who selects and appoints, but you can have a judicial appointments committee as well. Both can work very well, both can be corrupted as well. So there it is not from that point of view, it is not necessary to have a council. Sometimes councils, in my experience, have so many powers that it is the powers are concentrated, and then it is very easy for mala fide executives to grab the judiciary. So that is a thing you must consider when you look at a model. But if you have a strong, powerful council with the right people in it, it is probably the best protector of the rule of law and the independence of the judiciary, which you can imagine. And another advantage which you see in some councils, you see it more in the north of Europe. You see it in Norway. You see it in Finland. You also see it in the Netherlands. Gradually, these councils, they move from appointments and disciplinary to developing what is necessary for the judiciary. So digitalization, all kinds of other things. And they have it in their own power to do so. They are not dependent from the executive or the money from the executive anymore. And if you have this strong councils with these powers, the judiciary shapes more or less its own future. And that is probably a thing that is important for the future of the judiciary in Europe. I have no idea how long I've been talking. Okay, that is great. That was what I expected. Thank you very much.
Thank you, Kees, for your interesting input. I would like to ask about European standards for the appointment of judges from International Association of Judges perspective. Are there any judgments of European courts, such as Court of Justice of European Union or European Court of Human Rights? Any recommendations of international organizations which try to create some standards in the process of appointing judges and some standards as for the structure of National Council for the Judiciary? And these are the questions I addressed to Mr. Duro Sessa. I give you the floor.
Thank you. First of all, thank Justitia for inviting me, and actually it's a real honor to be here and fight of Justitia is inspiration for all the Association of Judges in Europe. And one other thing that Justitia and the situation with Turkey and other serious problems in judiciary brought together the European Association of Judges to work on those issues, and the results of that are the platform for Turkey. It is our case before the European Court, and so this is something which is really inspiring for all the judges in Europe. And whenever we get together in different occasions, those are the topics we speak about. Speaking about the European standards of the appointment of judges, a lot of things have been already said, and so I will try not to repeat them. But let me start with the story, because we were speaking about the culture. In 1988, the Minister of Justice from Croatia, then a part of Yugoslavia, visited one provincial court. And his background, he was a military prosecutor before becoming the Secretary for Judiciary. And he started his speech before the judges who were invited, that in preparation of this meeting, he was astonished that 2 judges of the court are not the members of the Communist Party. That is the culture, and that is the background. So the councils of judiciary have been established to solve that problem. And it is true that Council of Europe were thinking about councils after the fall of the Berlin Wall. And nothing is bad with that. And those countries who didn't experience this kind of culture I was speaking about are also established the councils because they come from dictatorship. That was Portugal and Spain, Italy. So there is nothing wrong with having the councils, even though in those countries where the culture of independence of judiciary and judges is well established. It is well rooted in the mind of the peoples, and that's why I think, as Churchill said, democracy is not the best system, but the only one we have. So that I think the council is one of the this could be used in the argument for the councils. I will try. I divided my intervention to speak about what the EIJ has on that, and the European Parliament, Council of Ministers, Venice Commission, CCJ, and European Court of Human Rights. No, I can do it. Here, is it here? Yeah. No, here.
The big one.
The big one.
Yeah.
Okay. Thank you. So, of course, International Association of Judges is the largest judicial association. It has 93 members from all over the world. And the European Association is actually the part of it. So we are not as autonomous in Europe as other European associations. But In 2017, in Chile, the association delivered this Universal Charter of a Judge. And it is an effort which brought all 93 associations together from all over the world to find the wording which would satisfy all the associations and which would be something which all the associations in the world can stand behind. So there we said that the Council for Judiciary are something, the body which has to protect the independence of judiciary. So it is not only appointment, it is not only discipline, it is not only promotion, it is not budgetary issues, organization of judiciary, it is protect of the independence of judiciary and individual judges. And I'm not sure that many councils in Europe are taking this and standing behind judges when they are attacked from different sources, including media. So this is something which the Council of Judiciary should do as well, and that is what European Association of Judges, International Association of Judges has said. Also, we were speaking about the composition, and that they shouldn't be only advisory bodies, and that they should have the largest range of authority and be recruitment, training, appointment, promotion, discipline of judges, and that most of the members should be judges. So that is what EIJ had in 2017, and so far nobody is thinking about changing this charter. And what is important with all these documents from the international point is that they are somehow the result of a common knowledge and experience and wisdom of many people who are very involved in the matter. And so the value behind that is this fact, that it is a result of many considerations and talks and the discussions, which that the same is for the EIJ and for the Council of Europe and the Venice Commission and the court at the end. So one of the interesting part is what the European Parliament in Strasbourg said about the councils in the case of Germany, where they somehow proposed to Germany to establish the councils of judiciary. And we know that there are long discussions in Germany about that, but that is something which in 2009 European Parliament proposed to Germany, and so it can be used as a common ground and a stand from the Parliament to all European countries. But only few don't have councils in some sort anymore. It's Austria, Germany, Czech Republic, and I can't remember, is there any other one? Luxembourg. Yeah, Luxembourg is easy. Of course, there then is a recommendation 2012, something which is considered as the 10 commandments of judiciary in Europe, and there also the Council said that the role and the task and the duty of the councils is to establish independence of judiciary and to protect the independence of individual judges, and that in the composition not less than half should be judges elected by their peers. And why this is important? Why the councils are somehow ground for judges to be safe, to be brave, because if they have the councils which are composed from judges and that know that their peers are deciding on the issues which are important for their career lives everyday work, that they have a people who would understand what the essence of the everyday work of a judge is. And I think that is very important, that there are statistics, there are numbers, there is objective criteria, there is everything. But we have in one of the CCG opinions that numeric criteria are sometimes only give the impression of the objectivity. So there is this gray area where, if it is used in proper way, can make a difference. When you, as a judge, can see what this judge is doing, what are his decisions, how he deals with the cases. So it is not always numbers which can give that, because if that, we will have artificial intelligence deciding on the career of judges, which is also a possibility. So the recommendations also says that this decision should be based on merit, and that the decisions on the career of judges should be delivered by the independent body, and so it is all what Dalia already said. Of course, the Venice Commission was also dealing with this criteria. They have this list of independence of what makes judiciary in a country independent or seen as independent. And one of the elements is appointment of judges and existence of the councils as one of several points which they take. Also, they were in different opinions the Council of the Venice Commission is giving on a particular countries. They advocate the councils as a way how to protect the independence of judiciary. Of course, I must say that the Venice Commission is sometimes tailor-making opinions. They try to also please those who are asking the opinion from them. So they are not very strict to the previous opinions on a similar cases. But again, from the documents, there is a hard line which they never cross so far. And of course, we come to the CCGA, which I'm very emotional of, because I'm the part of it from the very beginning. And in different opinions, we were dealing with the councils of judiciary and appointments. And if you read these opinions, the council, the CCGA evaluated from the opinion number 1, where it was rather shyly said advocating the councils, but not very strong. The CCGA embraced the Charter for Status of Judges from 1998, which was not a binding document of the Council of Europe. But in the first opinion, we were doing just that. Then, later on, in opinion number 10, it was developed in more concrete way, because the opinion number 10 was devoted to the councils only, where we were speaking about composition, asking for substantial majority of judges. We were speaking about election, advocating that the members from the judiciary should be elected by their peers, that the members should represent, give the largest representation of the judiciary. So that means the judges from the different levels, from different kind of courts, and that if some members are elected by the parliament, that they should should not come from the rank of politicians, but more from the academia, independent legal professions, or civil society. Also, speaking about the task, we advocated the largest possible task of the councils, and especially to be competent in the selection, appointment, and the promotion of judges. One opinion I think is also very interesting, and it is not so well known. It is opinion number 19 on the role of the presidents of courts. And one part of it is devoted to the selection of the presidents of courts and the selection and appointment of presidents of the Supreme Court. And in that opinion, we said that the presidents of court courts should follow the same path in the appointment as ordinary judges. So the council should be that body which will appoint the presidents of courts. And for the presidents of the Supreme Court, we think, CCJ thinks that the best way is that the judges of the Supreme Court will elect the president of the Supreme Court, which is not very likely in many countries. Then lately, in opinion number 24, Anna should say more about it because she was mainly the author of it. We more developed the role of the councils, strengthening what already has been said in opinion number 10. And there we also said that there is no single model, of course, for the councils, but they should have adequate competencies to defend and the independence of the judiciary. Later on, just to mention Magna Carta of Judges, it is somehow a declaration of the CCJA on its 10th anniversary of existence, where all these main points in previous opinions had been put together, and so we were also speaking about the councils advocating this. Of course, we come to the European Court of Human Rights, and in this famous case, Campbell and Fell, the court said what are the elements, how the Article 6 is protected in the term of independent tribunal. And so it said that it is a manner of appointment, term of office of judges, the existence of guarantees against outside pressure, including budgetary matters, and his judiciary appears independence in the eyes of the general public. Later on in this case, Lamborger versus Sweden, the court explained what is independent tribunal, saying that it should be that the judges should be independent from the executive. And at last, I will come to the case of Iceland, which has been already mentioned, so I'm not going to speak about that, because we know what the problem is, but what is perhaps interesting is what is the outcome of that case in Iceland. And there are three consequences. First, the judge who was in question stopped to sit in the cases of the Court of Appeal. Second, all four judges go to the process of reappointment, and three of them have been reappointed following all these principles of following the proposal of the independent body. And all the cases where that judge was involved in were reopened and again heard. So that is the example how the Iceland took seriously the judgment of the European Court of Human Rights and changed their own system or show more willingness to follow the principles of establishing the European Court of Human Rights. So thank you for your patience.
Thank you very much. It was really, really interesting. There's one last question I would like to ask during this panel. What is the relation between the concept of a tribunal established by law and the Polish system of appointing of judges? Can we make some general statements on that matter? That is the question I addressed to Professor Krystian Markiewicz. Krystian, I give you the floor.
Dziękuję bardzo. Thank you very much. We agreed that we'd have intermittently a presentation and then no presentation. I will not show you a presentation. There are advantages. The good side of the 8 years of rule of the Law and Justice Party in Poland is that we have contributed to the case law of the courts in Strasbourg and Luxembourg as regards the definition of a tribunal established by law. It would indeed be difficult to discuss the matter without referring to rulings judgments concerning Poland over the last few years. As I said, this is a fundamental premise that needs to be examined in the context of the right to a fair trial, and a breach should lead to the presumption that the state is not guaranteeing an independent and impartial tribunal, and this is the duty of the court to provide it to anyone who goes to court, and they are entitled to expect that anyone who takes their case to court in Poland and in Europe will have their case heard by a properly established court and not be a casino where you never know what the outcome will be. As a European, I have the right to a legally established court, established based on law, not only in Poland, but in every country of the European Union and in every country that agreed to abide by Article 6. So, this is a dilemma that Kes already referred to, where on the one hand you have different ways of establishing courts, but ultimately there is a minimum standard that must apply everywhere, regardless of tradition, regardless of domestic legislation. I was wondering whether to begin these comments by discussing the Icelandic, the Astrathson case. Fortunately, Duro has already covered this, but I will refer to something that I consider crucial. It's not that well defined, but it's crucial. It's what Kes spoke about in Maastricht last month, and he referred to that. He made a mention of that today. Namely, what should be the objective criterion determining that someone is a judge? Technical qualifications, code of moral conduct, integrity, or a readiness, a willingness to guarantee rule of law, to stand up for rule of law. And in the context of what Maria Rosaria said in her presentation about the transparency of the process, and this has to be taken into conjunction, because a clear and transparent, predictable process must serve a purpose. Of course, as I understand it, the purpose it serves is to meet the objective criteria, because my job, my task is to compare these criteria with what we have in Poland. And no one in our country has any doubt that these processes in the neo-NCJ are predictable and based on clear criteria, but that's not the point. And nobody is saying that the Polish National Council of the Judiciary complies with the requirements we've presented. Over the last few years, most of the judgments of European courts in Polish cases have to do with the attack on rule of law in Poland. This is an assault carried out by political parties, the party in power, an attempt to undermine the courts. It began with the Constitutional Court, which began a political body, the third chamber of parliament, but the crisis was also derived from the process of appointment. The president refused to take an oath from 3 properly appointed judges, and the new parliament appointed 3 other judges that were more in line with the political party's requirements or expectations. As for those judges, the European Court of Human Rights judged that they are not a court established by law after the Polish Constitutional Court, as was to be expected, questioned the primacy of European law and actually challenged Article 6. The European Commission launched infringement proceedings. This has been going on for some time. Some time ago, it says that it filed an application with the European Court of Human Rights. As far as I know, the matter has not yet been registered in the Court of Justice. A number of cases heard in Strasbourg and Luxembourg had to do with the process of appointing judges in Poland. And let me say that the commonality is at the root of this evil is the neo-NCJ in Poland, a body which under the Polish constitution has a specific composition appointed in a specific way. 15 of 20 members are judges appointed by judges. And its purpose is to guarantee the independence and impartiality of the judiciary. The constitutional ground of this body did give it legitimacy to be an NCJ. Did the Polish constitution change? Has the Polish constitution changed? No, it hasn't. In reference to what Duro says, the constitution didn't change, but on the other hand, everything did change. The provisions of the act were changed, the procedure was changed, the term was cut short of the legally appointed NCJ, and it is a purely political process. The body, the authority, isn't not standing up for the independence of the judiciary, but conversely, it is criticizing and attacking judges who adjudicate the way they should. And two comments are referring to what the previous speakers said. If we were to accept that that hard law, if we believe that the hard law should be that at least 50% of the judges should be appointed by judges, by their peers, and if we accept that it's hard law that such a body, such an authority should in essence and in practice uphold independence. So these two elements that can be required that are in line with European standards, the answer is simple. The Polish National Council of the Judiciary is not consistent, does not comply with these requirements, but it's in its second term now. The neo-NCJ is in its second term. The third target of the authorities after the Constitutional Court and the NCJ, which is taking over the Supreme Court. Following changes into the Supreme Court, special chambers were established, a repressive disciplinary chamber, the purpose of which was, together with the disciplinary advocates, undermine independence. It existed for a few years, but thanks to the resolve of Polish civil society and legal circles in Strasbourg and Luxembourg, the Polish Supreme concluded that it's not a court established by law. The Supreme Court even determined that it's a special court, which may in Poland be established only in wartime. European courts and the Polish Supreme Court did not rule on whether the persons in these bodies are judges, but it did rule whether they can adjudicate in line with these standards, and said they cannot. Let me add that this had to do with two issues that we are currently looking at: a tribunal, a court in the institutional sense, but also the process of appointing judges to that court. And that quote-unquote court was established exclusively out of judges who were appointed in an irregular manner. This irregular manner, it was a flawed competition process, and the unconstitutional NCJ was involved, and the Polish president, even though the Supreme Administrative Court suspended the process, didn't listen and made the appointments. So consequently, Poland gave way, Poland succumbed and abolished the disciplinary chamber, but this was just a partial success because the professional liability chamber, professional responsibility chamber was introduced, which is only somewhat different, but it's still composed of neo-judges. By the way, this chamber of professional responsibility was discredited early in the day by the writers, by the present party in power, which has drafted another piece of legislation to the effect that this chamber of professional responsibility is not a court. To make it even more interesting, in order to obtain billions from the Recovery and Resilience Fund, only 4 judges, disciplinary cases will be heard by the Supreme Administrative Court, but other professions will be judged by the existing courts. So we have 2 categories, those who have the right to have their cases heard by a legally established tribunal and those who do not. Along with the disciplinary chamber, there was another chamber established, the Chamber of Extraordinary Control and Public Affairs, which determines on the status of judges. It hears appeals in the nomination process and rules on the validity of parliamentary and presidential elections. This chamber was entirely in toto established in the same way as the disciplinary chamber, with the same flaws, the same irregularities. I will be quoting a ruling by a judgment by Strasbourg as to the judges in this chamber. The arguments regarding the judges in this chamber also applies to the neo-judges in the Supreme Court who were appointed in the same manner. The court in Strasbourg, in a binding Boldolistra Fice-Kanozimek versus Poland, ruled that persons appointed to sit in this chamber are not do not meet the requirements of a tribunal established by law or independence and impartiality. The irregularities in the appointment process were judged by the court to be clear, obvious, and related to the basic rules governing the appointment of judges. The court concluded that owing to the participation of the NCJ in the nomination process, the intervention of political authorities in the nomination process, the fact that the president failed to respect the suspension of the nomination process by the Supreme Administrative Court, that this undermined the legitimacy of the court, which was composed of judges appointed in such a way. And it concluded that the Supreme Court, the Chamber of Extraordinary Control and Public Affairs, it was deprived, cannot be considered a court established by law under Article 6 of the European Convention of Human Rights. And consequently, these irregularities are systemic in nature. These breaches are systemic in nature and will in the future impinge, affect the way other applications will be examined. The Chamber of Extraordinary Control is not a court, but it is the one that determines that rules on judges' appointments, and this non-court will determine whether parliamentary elections in Poland are valid or not. So this wording in the judgments that I've quoted is still applies, is still valid. is still taken into account by the Supreme Court, the chamber of the criminal court at the administrative court, and they can tell you what the outcome, what happened when they tried to put these judgments into effect. Then Grzenda versus Poland, 2022. And there, the court in Strasbourg referred to the important role of the NCJ in the process of nominating judges as a guarantor of independence of judges thus appointed. It ruled that there is a clear connection between the integrity of the appointment process and the requirement of judicial independence. Yes, the court did accept that states can choose various ways of nominating judges, but it did refer to various common elements and said that regulations should not be treated in an instrumental fashion. In the Grzenda versus Poland judgment, Grzenda was a judge whose term was cut short, whose term in the previous legal NCJ was cut short. The court in Strasbourg focused on the activities that undermined judicial independence in Poland, starting from the Constitutional Court through the NCJ, the Minister of Justice, which in a relevant way curtailed the independence of the judiciary. So this is the jurisprudence in Strasbourg. Unfortunately, judgments are one thing, but where Poland is different from Iceland in that nothing has changed. The nomination process is continuing. Most of the Supreme Court is composed of neo-judges. We have nearly 3,000 judges in the ordinary courts. So what about the ECJ? I will refer only to one judgment of the ECJ, but I think it is very important. I'm C204 by 21 of October 2021. This judgment was the outcome of a request for a preliminary ruling made by 7 Supreme Court judges on the effects of what happens when one of the neo-judges in the Chamber of Extraordinary Control, who took the files, who took the records from another bench, another Supreme Court bench, and gave a ruling as he pleased, as he desired. The court in Luxembourg said that this was a breach of the law and gave the Polish Supreme Court the opportunity to recognize that this act was invalid. And this was in October 21. The court in Luxembourg said that it's for the Polish Supreme Court to dot the I's. Dariusz Zawistowski was on the bench, and what happened in the Supreme Court? There was an instrumental change of the bench. The files were taken away. The new bench was composed mainly of neo-judges who were expected to adjudicate, to rule in their own case. Małgorzata Manowska, the president of the Supreme Court, and the president of the civil chamber. There's no judgment in this case to date. So the judgment of the Court of Justice is a dead letter judgment at the moment. It's not the case that political authorities are saying that they will not execute Strasbourg and Luxembourg judgments. This is also done by persons who have been appointed in this way, the neo-presidents and neo-judges. What happened to the right of fair trial to persons whose cases are heard? This is Judge Żurek. Is this an isolated case? No, it isn't. A few days ago, we all heard how another case heard by the Supreme Administrative Court on whether the Administrative Court can examine the legality of the nomination process, the decision of the president. A day before the judgment, the acting president of the Supreme Administrative Court took the files, suspended proceedings, and put the files in to the Constitutional Court, and we can wait for any amount of time. So is this an exception? No, it isn't. There were over a dozen cases, Monika Frąckowiak and myself, which had to do with determining the status of neo-judges in the Supreme Court. These were handed back. These were sent back referred by the court in Luxembourg to the Polish court, but were they referred back to the original benches? No, because the Małgorzata Manowska also took the files and referred them to the Constitutional Court, where no one will have access to them. This is a serious problem, which has to do with not only the standards, but also the way these standards will be put into effect will be. What I've said so far had to do with nominating people to the Constitutional Court and the Supreme Court, but it's just the tip of the iceberg. We have over 3,000 judges in the ordinary courts, where we have this issue regarding their nomination process. Are they actual judges or not? It is accepted that whether a court is established by law, that is determined in domestic legislation, so it seems very simple. The Polish constitution provides for two conditions. There is a motion by the NCJ, an NCJ appointed constitutionally, and then the president's decision. If, as determined by the administrative court, this NCJ is not an NCJ as understood in the Constitution. The whole appointment process is invalid. This is the draft of Justitia, which also assumes that there will be new competitions that candidate judges will need to win, will need to take part in and win. So these persons don't pass the Astradson test. This was confirmed by Strasbourg, Astradson test, because they were consciously involved in a procedure that's inconsistent with regulations, and because they are complicit in an attack on the Constitution by being involved with the illegal NCJ. They don't pass the test mentioned by Professor Kress Sterk. What technical qualifications can we speak about if the qualifying body is illegal and the nomination is determined by party affiliation, and anybody who is appointed judge because in violation of the rule of law. These are judges we're talking about, judges who have been appointed in an unconstitutional manner. And this is the gist of the problem. And this is the last test, the third and final test that brings together the previous ones. The nomination process should be carried out with the participation of judges. 50% at least should be appointed by judges, and this is a test of independence. Is this the case? No. The nomination process needs to be legal, transparent, and because it will ensure the selection of judges who are competent and who have integrity. And there's a problem we have. We have effective control of the nomination process by an independent court. Was this present? No, as was ruled as per the judgment of Strasbourg. In conclusion, Poland is a EU member state. We're part of Europe, and now what are we talking about? We're talking about constructs on how to uphold all these values. Whether is this a judge, or maybe it's a judge but not a judge who can adjudicate, or is this a court but institutionally but as an employee court, or is this actually a judge who's not allowed to adjudicate but only in matters that refer to EU law? So what are we doing here as lawyers? We're supposed to come up with constructs to defend people who put their personal career above the right of citizens to an independent tribunal established by law. This is a regrettable vision of Europe, and I hope that's not the way we'll be going. I hope we won't be forced to seek constructions that substantiate, that validate misrule or illegal action, and we'll do everything not only to set standards because we agree on standards, but we also need to consider how to make sure that these standards are required and implemented, and I demand that the European Commission, after all these years, finally wake up and launch infringement proceedings regarding the Polish NCJ, because if it fails to do so, it is also complicit in the fact that the Polish judiciary and the European judiciary is being poisoned by individuals who are not a tribunal established by law. Thank you very much for your forbearance.
Okay, that was very, very strong input. There should be the moment to ask you whether you have questions or comments, but as you probably see, we don't have time for that. So we have to skip this part and postpone it after the second part of the panel. Now, I would like to ask you for 5 minutes of break. No?
I think it's 10 will be.
10 minutes. Okay, 10 minutes of break, and then we'll come back here. Thank you.
So good morning once again, everyone. Thank you for coming back after the break. And after these interesting speeches of the first part. To be quick, not to shorten the hopefully interesting debate we will have after these four speeches, I'll just make a quick introduction of each of our speakers. We will have, first of all, Professor Ann Sanders. She's the chair of the Civil Law and Law of Family Business and Judicial Studies of the Bielefeld University. I hope I've pronounced it roughly. She's also a professor and member of the Rule of Law group of the Bergen University in Norway. And she has been an expert for the Council of Europe and the CCJ. We have had the privilege of having her as expert for the Consultative Council of European Judges in some of the opinions issued in recent years. It's not the first time we have also the privilege of having her in a MEDAL conference. If I recall, we also had Professor Sanders in a conference we organized in Berlin in the beginning of 2018. Then we would have as speaker Judge Nuria Diaz-Abad. She was del Estado at the Audiencia Nacional in Madrid. She has been an agent for Spain at the European Court, the Court of Justice of the European Union, and she is also former president of the European Network of Councils for the Judiciary. She was president between 2016 and 2018. Then we'll have Gabriele Fiorentino. He's a judge in Rome, currently acting as Deputy Secretary General of the Superior Council of Magistracy in Italy. And finally, this will be harder to pronounce, I'm sorry for my Polish colleagues. Bartosz Wodokiewicz, sorry, he's an associate professor of civil procedure at the Warsaw University, and a member of the Interdisciplinary Center for Research and Judicature. So I think from the presentation quick presentation I just made, we will have very interesting speeches, and not to prolong anymore, I'll give the floor to Professor Ann Sanders.
Thank you so much. This is an extreme honor of being here. And I must say that I'm again and again deeply impressed by the work done in Poland by Polish judges. And I hope this is right. I really ask for correcting my attempts with people to do that in Polish. Okay, so now I'm going to speak about the German judicial system and the practice of appointment of judges in Germany. First, I want to make some quick notes about the German judicial system so you can put everything I say in context. In Germany, there are 5 specialized court systems with specialized judges. Ordinary courts, covering civil and criminal cases, administrative courts, tax courts, labor courts, and social courts, all with their own judges. And then it's important to keep in mind that Germany is a federal state. The first and second instance courts are organized in the Länder, in the federal states, for example, Bavaria and North Rhine-Westphalia. And the 5 Supreme Courts are organized, administrated at the federal level. When it comes to judicial independence, it's also important that Germany is a bit special in that respect. Independent decision-making of judges, job security, the right not to be transferred against one's will, is all protected. And all decisions concerning a judge's career, evaluation, etc., can be challenged in court. I think this is important to note. However, there is no institutional independence in Germany. The majority of constitutional scholars in Germany do not think that institutional independence is protected under the German constitution. And there is no council for the judiciary, neither in the Länder, not on the federal level. But this is not to say that in Germany, judges don't have a voice at all. They participate in a number of important decisions. In the selection of judges, in the distribution of cases, and disciplinary procedures are decided by judges at special courts. And I can also say that I have not heard of a case where the executive or legislative body has interfered with the decision-making of an individual judge. So I think the actual independence of judges in Germany is quite high when they work. But courts are administrated by court presidents for the executive. So courts are bodies belonging to the executive, and they're administrated by judges for the executive. But in those courts, independent judges work. This is a bit difficult to understand, but I think it's important to keep in mind. So let's come to judicial appointments. The first appointment usually happens right after the second state exam, so when young lawyers finish their education, and at that point they're quite young. And I think this is also important to keep in mind. If young judges join the judiciary, they're socialized within the judiciary. I think this is important for informal aspects we also need to keep in mind. Because as we heard this morning, culture eats formal rules for breakfast, so formal, informal rules need to be kept in mind here in culture. At the moment in Germany, good candidates are in extremely high demand. We don't have enough applicants. We have a big number of judges who will go into retirement quite soon. And so young judges, young good people are in high demand. And so it's not, I don't think at that level there's any politicization, because in most cases they're just happy to get some people. Might also have to do something with our rather low remuneration, but that's another point. A candidate, if you, as a young judge, young person want to become a judge, you apply to a higher regional court for the specialized judiciary you want to join in your federal state, in your land. For example, in North Rhine-Westphalia. And then the selection of these judges is done by judges in those courts. The representatives of the judges within those courts participate in the selection. And it's also important to note that merit appointment is extremely important in Germany. It's considered a constitutional value. So grades of the exams are really decisive in this election. One can talk a lot about exams in Germany, but that's another question. But it is definitely, you could call it an objective criteria. It's also important to note that the way the executive participates in these decisions differs from land to land a little, but usually one can say the first selection is done really by judges, and then the appointment is more or less formal by a Minister of Justice. In some of the Länder, there are special committees in parliament, Richterwahlausschüsse, and in some of those even judges are present, but that's never ever in a majority, but there's just a few of them. Let's turn to promotions. There are differences in between the Länder again, and it's also important to note that the difference of pay after promotion is not that big. And it's also important to note that the representatives of judges within the courts, they are heard in this process, and they look if the preconditions of the advertised positions are met. So if there's an open position for a promotion position, the position is advertised and judges can apply to that. And then the selection is more or less done in the Ministry of Justice. But the representatives of judges within the courts are heard in that respect. And there are again differences between the Länder. It's also important to note that decisions concerning promotion can be challenged in court. And this happens quite often, it does happen. And these claims are sometimes also successful. So even while the executive is involved here, judges give voices in it, but even if the executive really is active here, there is a lot of judicial control about it. Like the first appointment, promotions must be based on merit. And this is again the question of what is actually done when a decision is challenged in court. And merit within the promotion system is determined by looking at a judge's evaluations. Judges are regularly evaluated by the court president. So this is some part what the court president, who works is a judge but who works as a president for the executive, does as a sort of, not a boss, but as some member part working for the executive, evaluating judges. However, these evaluations must not affect judicial independence. So it's quite difficult. The court president must sort of be very careful not to violate a judge's independence this way. This is very hard. But again, it can be challenged in court. So if something is done in the evaluation that really violates a judge's independence, for example, if a president says this judge should use less oral hearings, he should do more of his cases in a written process, then the judge can go to court and say, here, this violates my independence. He cannot tell me what I can do and not do in my courtroom. And this is also done quite often. It happens. So it's not something that's only theoretical. What is considered important in these evaluations? Work in different areas of law, whether a judge works in court administration, whether he or she is ready to help in the education of young judges, whether this person has done a secondment to a higher court. Actually, if a judge wants to be promoted from a first instance court to a second instance court, it's important that this judge has done a kind of secondment, a kind of trial period as a higher court to show that he or she is up for the job. So this person works for about 9 months at the higher court and then shows, okay, I can do the job, and is evaluated for that. There are also other kinds of secondments. There are secondments to Supreme Courts and to the Federal Constitutional Court. And there are also secondments to ministries. And if those of you who know the applications to the European Court, the C-276 out of 20 decision, the judge there in this case talks about these secondments to ministries, especially ministries of justice. So as a special kind of working experience, a judge can be seconded for a couple of years to a ministry to work there within the ministry. And in that work, this judge is not independent because the judge then works within the structure of the ministry. All the people I know who have done that really like the experience because they participate in the drafting of legislation, they learn how things are done in ministries. But of course, this can be criticized that there is too much of a sort of, that the executive and the administration and the courts come too close together. However, I have never heard of a case where actually this was used to actively influence a judge's decision-making later. And I have a couple of friends who did that, and they really appreciated the experience. And they said that judges, on the other hand, may have a sort of influence on the drafting of legislation this way. So, of course, we can debate that, but this is you should see both sides of it. The judges I know tell me that at least from the first instance to the second, so the first step of promotion, usually political considerations are not involved. However, important positions such as court presidents definitely have some sort of, and there are again and again cases within the German judicial system when cases of appointments of presidents of courts are debated, and whether how much political importance was given to them, how much political consideration came into that. And this becomes even more important the more important the position of this person is. However, I must say that sort of all in all, one can say that even at that point, merit does play a role, and because of this threat of the challenge in court. And even court presidentship. People go to court and say, no, I would have been the better candidate. Please, court, ban the appointment of the other candidate. And this happens. This does happen. So while this system has its downside, it does have the upside, the strength of real judicial overview in a way. Okay. Let's turn now to the federal system. On the federal system, the promotions that go to the 5 Supreme Courts, we have a special situation here. Here, the decision is made by a parliamentary selection committee, so-called Richterwahlausschuss. And the members are elected by the federal parliament. They include the ministers of justice of all the Länder, they're present then, and also members of parliament. And the federal minister of justice then appoints the candidate who is elected by this parliamentary selection committee. A member must suggest an applicant. So if you as a young judge want to apply, you just cannot apply because the positions aren't advertised. You must find a member who advocates for you, who brings your application. But even here in this system, judges have a voice. The judges of federal courts interview applicants and evaluate their work. So, for example, the friends who have applied, they have to send in a couple of decisions, and then the decisions are evaluated by judges then, and you have an interview with them, and they find out if this person is up for the job or not. And if the judges of the federal court, this applicant wants to join, if they say no, this applicant is incompetent, he or she has not the right kind of experiences, they can veto an applicant. And this applicant is not appointed then. The system was challenged in the Constitutional Court and was seen, the Federal Constitutional Court of Germany decided that it was constitutional. Criticism. There's of course, a lot of criticism about the system, especially for the federal system. It's criticized as being intransparent, and that political consideration can play a role for high positions, for chairpersons and presidents. And there are demands by the judicial associations in Germany that judges should have more institutional independence. And they advocate that there should be judicial selections committees of parliaments with judges elected by parliament as members. There is not a real argument to have something like the old Judicial Council in Poland, unfortunately, because this idea is very strong in Germany that you need democratic legitimacy and that somehow you need someone who is elected to finally appoint and select someone. This is something that should be debated more strongly, maybe considering constitutional amendments and so on, but this is how the discussion is at the moment. There is in the 2022 ENCGA survey where a lot of German judges participated, about 67% of them doubted that promotions are based on merit alone. So there is this kind of problem. There have been applications to the ECJ, not two, but more. And the first one, the Land Hessen, was unfortunately turned down with a rather short explanation, saying that just because the parliament is somehow involved, that doesn't mean that it's not independent. There is another case still pending of the Landgericht Erfurt, and I'm happy to say more about that. I'll try to see how much time I still have. I still have four more minutes, so I'll say a bit about that. The case brought forward by a judge at the Landgericht Erfurt, and as a first question to the ECJ, it asked something that was connected to the so-called Volkswagen diesel scandal, so to the question of there was this fraud concerning, you all know that. And the second question, this judge asked whether this court was independent in the sense of Article 19 of the TEU and Article 74. And it repeated some of the arguments of the VG Wiesbaden, but it also sort of brought a bit more flesh to it. It criticized the role of the executive in appointments and promotions, the role of court presidents as to being too close to the executive, a lack of institutional independence, and arguing that the involvement of judges, representatives on all levels was not enough. And also it criticized the informal practices I already mentioned to you, the practices such as the secondment and the internships at ministries of justice, for example, and that this could endanger independence. So this was brought forward by this case. Actually, given the argument of the ECJ in the Land Hessen decision, I'm not sure whether it will go further than what they said in Land Hessen. I'm not so sure about that. It seemed they have found a solution for the first question with other cases, so maybe they will just sort of drop the second question. I don't know. But they might also say that even though there are these critical factors pointed out here, that there are some sort of balancing factors in the German system, the factors I also pointed out. Things like that you can challenge evaluations in court, that you can challenge appointment decisions in court, all of that, and that you have judges, representatives. And also, coming back to culture, that there is, I think, a culture, so to say, among politicians that courts' independence needs to be respected in some sense. Okay, so this brings me to my last point. Yeah, oops, oh no, that wasn't the last one, yeah. Whether we will have a reform in Germany. I can bring you, I was at last year we had the Deutsche Juristentag, which is the sort of biggest conference of German lawyers, with several thousand participants, and they had last year the question whether Germany should reform its systems of judicial appointments and to protect judicial independence better. And I was one of the experts. Unfortunately, I was not the main reporter, but I was a reporter, I was asked to bring an international perspective. And I suggested to introduce an independent selection committee. Something like, and I brought as examples, I brought the Danish system, for example, and I referred also to the system in the Netherlands and in the UK, and I also referred, of course, to judicial councils, but I really looked at selection committees and said this would be something we could implement in our system without too much change. We could just have that, for example, on the federal level, and the selection committee would look at applicants, would also then make a recommendation to the Minister of Justice, who would then appoint someone, maybe a group of 3 or maybe just 1. And if the minister would appoint someone else, then the minister would have to give very good reasons. And I thought these reasons could then be very easily challenged in court. So I thought that this system could really be very well implemented into the German system as it now stands. But unfortunately, it did not receive a lot of support. There were, in the end, about 60 people voted for this, and my suggestions received only 7 votes. Yes, so you see how successful I was with convincing people. The general consensus of the participants, and I must say there was a big group of very powerful court presidents there, so maybe that tells you something. They said there is no need for a fundamental reform. What we can do is reform within the system. We can make evaluations more transparent. We can try to improve the legal procedures. We can secure the independence of the Federal Constitutional Court better. And we can also establish more specific criteria for promotion also to the highest courts. But we do not want a fundamental change. And the argument was again and again, oh, we don't want another system would not be better. I'm very sorry about this. I would have liked more courage there, more courage for a real change. And the argument there, of course, was now there would still be a possibility in Germany to secure the system against overtaking by politicians. Because, of course, as it now works, the system works quite well. It brings forward good people. even though, of course, it helps to have to know the right people, as in many systems it does, it helps to know the right people to make a career. But what I'm really afraid of is that if political situations change, that the tiny places where you can really influence the system and where you can use the system, they really must be closed as long as there's time. I think that the decisions made at the German Juristentag will help if they're used, but I would have liked, of course, to have more courage and more willingness for real change. Thank you very much.
Well, thank you very much, Professor Sanders. I think we have a lot of food for thought and for our debate after the remaining speeches. I would give the floor immediately to Nuria Diaz-Abad. I hope she is online and we can see her and she can see us and listen to us. Yes.
Yes, thank you. Can you hear and listen to me? I will
hearing-
try to share my presentation with you.
Okay, now we're hearing you.
Yeah. So, here we are. So, does it work?
Perfect. Okay.
Can you hear and listen to me?
We
Yes?
can hear you, and now we are seeing your screen. So please, the floor is yours.
Thank you. So, thank you very much. So, let me start by thanking the President of MEDEL, Maria Rosaria Guglielmi, the Vice President, Monika Frakowiec, and the President of Justitia, Christian Markiewicz, for your kind invitation. It was not possible to me to travel to Warsaw, but I'm very happy to share with you some thoughts on how the Spanish Council for the Judiciary is going through this question of applying European standards to the appointment of judges. So, I have divided my presentation in three parts. First, I will deal with the selection and appointment of judges, which is a competence of the Spanish Council for the Judiciary. Then I will go to the situation of the Council now. We should have been renewed in December 2018, so we are exercising our functions ad interim since then. And this has led to a limitation of the competences of the Council. Precisely, we are no longer allowed to make any discretionary appointments. I was tempted to call my presentation "How a Council Can Survive Without Doing Any Judicial Appointments." And last but not least, I will go to explain the current situation and what the Council is doing to survive and to uphold the rule of law. Well, the mission of a council is the safeguard of judicial independence, and a key point of this judicial independence is the selection and appointment of judges. Therefore, I would like to remind you that the ENCJ in the Dublin Declaration of 2012 already stated that judges should always be selected for appointment on the basis of merit and capability alone. So going to the selection appointment of judges, there are two different kinds of appointments according to our law. There are the ones that are regulated by law, the selection and first appointment of judges after an exam and the training in the judicial school in Barcelona, and then covering all the posts around Spain except the ones which are discretionary. And what are the discretionary appointments? The president of chambers, the court presidents, the magistrates of high regional courts that are elected on proposals of the regional parliament, and the magistrates of the Supreme Court. Yes? Can you hear me?
Maybe you have to do something on your screen, or maybe the slideshow so we can watch the following slides.
I'm passing all the slides.
Hearing you perfectly, but the slide on the screen is still the first one. So maybe you have to click on the slideshow on the bottom of the.
Can you now see the slides?
I think that's the last one.
Yeah, it's the last one. Yes. So let's move to the.
If you click on the slideshow, but exactly, that's it.
Now it works.
Yeah. If you click on the slideshow button.
And this,
I
the mission
suppose
of
that's
council. And number one, selection appointments, and now the different kind of appointments. Can you see
the
slide?
second slide, selection and appointment, and the next one, the mission of the council, I think.
Yes.
If you click on the
And
bottom right on the slideshow, I think.
I have on my screen the different kind of appointments. Can you see this?
No, we are still seeing the second slide with the topics of your presentation, 1, 2, and 3.
So,
maybe there's a
yes, because I tried it yesterday and it should work, but now I don't know how. You see now the different slides, the mission, selection and appointments.
The presentation mode is not active. You should maybe you should start with the slideshow presentation on the bottom near the Zoom.
Or maybe you can put the presentation online and I tell you when to pass the slides. Maybe this is
where you have now the arrow, the cursor. If
no, that's not better.
No, now we are just.
No.
This is Teams now.
Now let me try again, but if not.
I don't know if we have the presentation here.
No. Now it's a problem because I have closed the presentation. Now let me see how to do this.
No, you were sharing your screen correctly. I think you just needed.
Now you see it?
Yes, we are seeing you.
Do you see it now?
We see you.
No, we just see you. You're not sharing your screen right now.
Okay. Let me try to.
And I think the only thing you should need to do is start the slideshow presentation on PowerPoint.
Okay.
And after that, every time you click, it just goes to the following slide, I believe.
Do you see the presentation now?
No, we're just seeing you. We're seeing and hearing you perfectly, but not the presentation. Okay, now we are seeing.
So I'm sorry, but
no. Now we are seeing the presentation and you, so it's perfect. I think you just need to start the slideshow. It's the only thing.
Okay, now let's try again. Now you see the presentation. Do you see the presentation now?
We see the presentation.
Full screen.
So if
and number.
Apparently now you clicked on the first slide.
Do you think now a slide?
If you just scroll,
yes.
If you just click on the slide you want to show us, I think that's enough. I mean, yeah.
Do you see now a slide called different kinds of appointments?
No, we are just seeing the first one.
Oh.
Europeans, the title.
Yes, but now let's try it this way. I click on each one.
Okay.
Is it now better?
We see the second one. Now mission
now
of the
third.
Perfect. That's it.
Okay, let's do it this way.
Perfect.
Okay, let's do it this way. Yes, thank you. So I was trying to explain that according to the Spanish law, there are two different kinds of appointments. The ones that are completely regulated by law, which are the appointments for the selection in the first appointments after passing an exam and the training in the judicial school. And all the posts in Spain are covered according to public competition among the judges, except the appointments that are discretional. And according to our law, there are four kinds of discretional appointments: the presidents of chambers, the court presidents, the magistrates of high regional courts in each of every 17 autonomies in Spain. There is a high regional court, and part of the magistrates are elected on proposal of the regional parliament, and last but not least, the magistrates in the Supreme Court. So when it comes to discretional appointments, which is the main problem for us, we have to discuss what are we looking for. We are looking for management abilities, if it's the case of presidents of chambers and courts presidents, or are we looking for, in the judicial post, for more technical abilities, which would be the case for the magistrates of these high regional courts and the magistrates of the Supreme Court. Well, according to the new Article 326 of our organic law on the judicial power and the Regulation 1/2010, there is a public offer and public criteria for these appointments. We have to publish it in the official journal, which guarantees the publicity of the whole procedure. There are some criteria approved by the plenary of the Council which have to be taken into account for the final decision. There's a clear distinction between management abilities and excellence in judging, and between common merits and specific merits. Then this new article introduces the weighting of these criteria, because it's not a public competition, it's a discretionary decision of the Council. Then we make a public hearing of the candidates, we record it, we web stream it, and everybody can look at these public hearings in our website. Then we need a reasoning of the proposal to the plenary, because the standing committee has, after the public hearing, to make a proposal that has to be reasoned of. It should be 3 candidates, but sometimes we have 12 on the list. And then we have to comply with the law on effective equality men and women. We need a report from the Commission for Equality telling us in this particular court what is the balance between posts covered by men and by women. So after this law change in 2018, we had to approve in the plenary in May 2019 some criteria to make this provision work. And we distinguish, as the law says, common merits of judicial excellence, common merits of management abilities, and specific merits when it goes to the Supreme Court or for presidents of chamber or for court presidents. When we look at the common merits of judicial independence, we have selected 5. The time of service in the judicial career, the time of service in the jurisdiction for which you apply, the time of service in a collegiate post, the knowledge in judicial abilities. Judges have to present 5 judicial decisions, and other legal activities or professions, mainly teaching, if they have published books or articles, or if they have worked as a lawyer or whatever. When we look at the common merits of management abilities, we look at the participation in management bodies of the judicial power, especially we look if they have this management positions in their courts, or if they have been members of the council. We look at the activities in collaboration with the council. We especially look at the action program, and we look at the decisions or reports taken in management functions, as well as they can submit us judicial decisions. They can also submit us the reports that they have taken in these management decisions. So what is the case law according to which we are working? I have selected 2 judgments of our Supreme Court that dismissed actions against the decision of the Council to appoint presidents of chambers of regional courts. In the first case, we took into consideration the fact that the woman we selected had been a member of a judicial network who have specialized in European Union law. There are 18 members all around Spain. They had their colleagues, if it comes to the case, to submit a preliminary ruling to Luxembourg, and it's a very strong network in Spain. And although the law does not foresee, we had not foreseen this specifically in the announcement of the post, the Supreme Court said that the law does not limit the criteria. It's not a numerus clausus. We can also take into account other criteria. And the second important thing the Supreme Court told us is we had to weigh all the merits, including the action plan and the hearing. So action plan and hearing will play a very specific role in the elaboration of the reasoning of the appointments of judges. The second judgment refers also to a president of the chamber of our regional court. It was also dismissed, and here we learned from the Supreme Court that reasoning of the discretionary appointments, the Council has a wide margin of appreciation. Discretionary is of course not arbitrariness, but we have this wide margin to appreciate the different merits put on the table. And it also says in the Supreme Court that an isolated and subjective comparison of merits cannot prevail, because the other candidate that challenged the decision said that we had only to compare the specific merits. No, we have to look at the whole merits that have to be taken into account. And now I would like to draw your attention on a case still pending at the European Court of Human Rights, the case Alonso Saura versus Spain. You have there the number of the request, and you can look at the merits of the case in the UDOC Basa date. Here it was the appointment of a president of a regional court in Spain, the court in Murcia. And we had three candidates. We had a woman, Mrs. Alonso Saura, and we have two men, the president of the provincial court, appellation court, and the responsible for the judges in Murcia. We selected this last person after two challenges in the Supreme Court, and also after a challenge in the Constitutional Court. The case came to Strasbourg. She has made of this case an allegation of gender-based for not appointment to a high judicial position. I frankly believe that this was not the case. We have two men, but for me, the case is very important because of the comparison of objective merits and the weight of the action plan. And here, let me remind you what I said at the beginning, that we distinguish whether it is a post with a merely judicial function, or with management competences. So the action plan was, in our view, very important, and the comparison of the objective merits was also something that has not to be seen isolated, but in relation with all the other merits. So let me come to the situation of the Council in Spain nowadays. The competences of the Spanish Council are foreseen in the Constitution. According to Article 122, the Council has four main competences: appointment, promotions, the inspectorate service, and the disciplinary actions. Organic Law 4/21 has limited our competences. Why? Because you need a 3/5 majority in Parliament to renew the Council. This majority has not been reached because the Conservative Party is against the renewal, and so the Socialist Party in government introduced this piece of legislation to cut the competences of the Spanish Council in a way to force the renewal of the Council. So the Council has not been renewed for more than 4 years by now, and this reform limits the competences of a Council acting at interim. The reform has been challenged before the Constitutional Court, and both questions are still pending. But one of the competences that were cut down was the competence to appoint two members of the Constitutional Court. And since the Constitutional Court has to be renewed June last year, a second piece of legislation was introduced in Parliament, Organic Law 8/2022, to make it possible that we appointed the two justices of the Constitutional Court, what we finally did in December last year. So what does the Rule of Law Report 2022 said about this situation? It addresses two recommendations to Spain. First, proceed with the renewal of the Council as a matter of priority. And secondly, initiate immediately after the renewal a process in view of adapting the appointments of the judges' members, taking into account European standards. Spain, as you all know, as well as Poland, are the only councils in the European Union where the judicial members are elected by Parliament. I will come later on to this. When I talked to the European Commission, in the framework of the interview in the rule of law report, I was very surprised that they put it this way, because first renew with a system that is not in line with European standards, and then modify the system. And I asked, why didn't they put it the other way around? Since I remember that in the third recommendation to the Polish government in 2017, the European Commission expressly says that it's not compulsory to have a council for the judiciary, but if you have one, it has to comply with European standards. Namely, it has to have a majority of judges members, and they have to be elected by their peers. And the European Commission gave me an answer that I found quite well, surprising. But they said to me, listen, Poland had a system that was in accordance with the European standards when they entered the European Union. And they have made a regression by changing this system and going to a system of parliamentary election of all the members of the KRS. Whereas in Spain, the system in place when we joined the European Union in 1986 was already a system of parliamentary election of all the members of the Council. So, according with the case law of the European Court, the Court of Justice of the European Union, in the Malta case, in the Republika case, you have the court enshrined in this case a non-regression principle. So, the European Commission understood that it could not say to Spain, it could not force Spain to go to a system of election of the judges members of the council by their peers. They can just say that it's a matter of priority to renew the council with the system in place. But with the system in place, we are in a complete blocked situation. So, as I mentioned here, there is a lack of compliance with both recommendations because no mechanisms are in place to unlock the situation, and because the reform of the system of the appointments is not compulsory. And I'm just looking forward for the next rule of law report, what the Commission will say to us. As I mentioned, the election of members of councils for the judiciary, as you see in this figure of the Justice Corps of 2020, Spain and Poland have different colors of the rest, and the reason is because in both countries the election is completely parliamentary. So let's go to the current situation, what the Spanish Council is doing to survive. We have many concerns about this situation. First, we have to uphold the governing functions of the Council. Then we have to uphold the trust in the system. And last but not least, we have to uphold the rule of law. So there are some vacancies that we cannot fill in any way. Because when the law was changed in 2022, the European Parliament turned to the Ministry of Justice asking what were the consequences of this law for the judicial system in Spain. And the then Minister of Justice sent a letter explaining that there will be no consequences because the Council for the Judiciary does not exercise any kind of jurisdiction. Being this true, that we do not exercise jurisdiction, we have to appoint the judges. And there are some vacancies that we cannot fill in any way. These vacancies are the Supreme Court, where we have 21% post vacant by now. These magistrates are mentions of high regional courts elected on proposal of regional parliaments that affects already 6 regional courts and the military jurisdiction. So what is being done? We turn to the Supreme Court to ask them what could we do in this situation, because we could organize a public competition so that lawyers or law professors could act as judges in the Supreme Court, or we could reinforce the Supreme Court with judges coming from other courts, or the solution that they give us, we could nominate new members for the technical cabinet to help them with the draft judgments. The situation in the high regional courts is solved by substitutions by other judges, and the military jurisdiction is probably the worst situation because the Central Military Court has no members by now. The last General, he went into the reserve situation in December, and we had to take some extraordinary measures for urgent cases, and always on a proposal of the military jurisdictions, but we are acting by now as a Council for the Judiciary as if we would have all these management competences in this field. So I have tried to explain you briefly what the situation in Spain is. Thank you very much for your attention. Sorry for the problems I had with this presentation, and I'm open to answer any questions. Thank you.
Thank you very much for the presentation and for your patience with us due to the technical problems. So I'll give the floor immediately to Gabriela Fiorentino.
Good morning to everybody, and thank you for the invitation. I will start immediately saying that the Italian system for the appointment of judges and prosecutors and the organization of judicial offices had a solid, hard law structure guaranteeing the autonomy and independence of the judiciary, and therefore the rule of law in consistency with the European standard. Appointments are made by both capacity, conducted through the assessment against a clearly defined and published set of selection competencies at all stages of the appointment process. Similarly, respect for the principle of what Italian Constitution calls the natural judge is guaranteed. It means that jurisdiction is pre-established by law and requires the competent court to be determined on the basis of rules set in advance of the specific fact to be decided upon, in order to prevent ex post determination of the judge dealing with the case. As a corollary of the aforementioned constitutional principle, in order to safeguard not only external but also internal independence of each single judge and public prosecutor inside the office, the heads of any judicial office must draw up a plan of action that is called tables in the court, stating that the regulation of the assignment, all the decisions taken by the Council on any ground are discretional, but they must be expressly and extensively reasoned on the basis of the predetermined objective criteria and can be appealed in front of the administrative judge, who and they are appealed very often, and the administrative judge may make them void on the grounds of legitimacy, which also comprises checking the logic adequacy and the formal consistency of the reasoning with the relevant criteria. More specifically, with regard to the issue of the judicial appointment, to become career magistrate, which is judge and public prosecutor, candidates have to pass a competitive public examination, which is required by Constitution. And the provisions regulating access to the judiciary have been amended several times over recent years. The discipline adopted in 2006 structured the examination as a second-degree competition, requiring certain qualification for admission. This system has been revised last summer when a bill passed stating that a law degree is the only necessary requirement to be admitted to the public competition. This amendment was the result of a strong debate in which many stakeholders, judges and public prosecutors associations in the first place, considered that imposing further qualification to candidates had the main effect of the selection being conditioned by the availability for the individual or his or her family of the economic resources sufficient to spend years studying without an income. In fact, such factual precondition had influenced the actual social economic composition of the judiciary. The examination includes both written and oral components. The selection is exclusively based on merit. The examining board, which is composed by judges, public prosecutor in majority, and academics, is appointed by the Council and makes an assessment based on culture, legal analytical capacity, reasoning, writing, and oral skills. Those who pass the examination are appointed magistrates. After the appointment, they must undergo a period of mandatory traineeship, and during which they do not fulfill any judicial function. The traineeship lasts 1 year and a half, and after, on completion of it, the High Council for the Judiciary apprises whether the judge or public prosecutor is suitable to take up judicial function. At this stage, balance, independence, diligence, and moral integrity are considered. Once appointed judges or public prosecutors undergo a professional evaluation by the High Council every 4 years. The heads of the courts and public prosecutors' offices holding managing and executive position are chosen by High Council for the Judiciary. Law provides for executive and semi-executive position to be temporary. They are conferred for 4 years. At the end of the term, the office can be confirmed only for another 4 years following a favorable appraisal by the Council for the Judiciary on the past activities. The appointment of the heads of the judiciary is the heads of judicial offices is discretional. The High Council conducts a comparative appraisal among applicants in order to choose the most suitable candidate for the position to be filled with regard to the functionality and possibly specific environmental requirements of the office. Using its power to issue quasi-legislative instruments, bylaws such as circular letters, which ensure self-regulation of the discretion, the Council approved the so-called Consolidated Act on Judiciary Management, which contains the regulation for selecting the management of judicial offices. As a further guarantee for judicial independence from executive power, Italian Constitution provides Article 108, which states that the provisions concerning the organization of the judiciary and judge and public prosecutor are laid out by law. According to the Italian Constitution, the judiciary is an autonomous branch independent from any other power. Differently from other legal systems in Italy, judge and prosecutor belong both to the same body of the judiciary, in Italian called magistrati. Constitution first established the independence of the judicial function and states that judge and prosecutor shall be exclusively subject to law. Independence, above all, is guaranteed by self-government through the High Council for the Judiciary, which is in charge of managing the career of judge and public prosecutor and exercises disciplinary function. Judge and prosecutor elect 2/3 of its members from among the ranks of the judiciary, while Parliament in joint sitting elects the remaining 1/3 of the Council members. Members elected by Parliament shall be experts too, either full professor of law-related subject or lawyers with at least 15 years of professional seniority. The Council is chaired by the President of the Republic. The President of the High Court and the Procurator General of the High Court are ex officio members. The High Council was primarily meant as a safeguard for the external independence of the judiciary, but its mandate covered as well internal independence, in line with the constitutional provision stating that magistrates are distinguished only on the basis of their function. The High Council for the Judiciary in Italy contributed to build a judicial system not only independent, but also framed as a democratic system. In a broader perspective, the High Council expressed over the years all the democratic potentialities deriving from its structure and position. It is indeed conceived not as an administrative body, but as a key constitutional power. For instance, the High Council reacts to inroads by media or political actors into the independence of the judiciary as a whole, or that of individual magistrates. is a specific function that the Council performs through public statement and formal resolution in the so-called judicial self-protection actions. With regards to the issue of today's meeting, the Constitutional Court decided a very important case concerning the concert, which is the consent, between the Ministry of Justice and the High Council that the law requires whenever the latter appoints the heads of judicial offices from among a pool of candidates. In the 1990s, the Ministry of Justice stopped the Council from finalizing a couple of key top-level appointment processes by denying his consent, as he maintained that he held the substantive powers to intervene in the selection of the most appropriate candidate. The Council then raised a conflict of attribution before the Constitutional Court, and the Court ruled in favor of the Council, stating that the Constitution bestows the exclusive power to appoint heads of judicial offices upon the High Council, the Ministry's contribution being a merely consultative one. Therefore, the Ministry does not have any power to hold the High Council from making its own choice, nor to hamper the finalization of the process by denying its consent. As Maria Rosaria Guglielmi noticed in a recent contribution, two factors allow the High Council to effectively perform its role. The discretionary power that it holds in the implementation of the legislative framework regulating the administration of the judiciary, and the representative features and the legitimacy that, according to the constitutional provision, the High Council has vis-à-vis the judiciary and its cultural pluralism. Criticism in Italian system have emerged with regard to the use of discretional power by members of the Council. Some of them have been caught discussing and negotiating the appointment of heads of important judiciary offices outside the Council with the exponents of political parties. In recent years in Italy, we must say that threats to independence came from inside the judiciary, not from outside. The events unveiled by the criminal investigation seriously impacted on the public perception of the judiciary and of its self-government system. The High Council, the National Magistrate Association, which is our umbrella association, and all the judicial associations have been targeted by several representatives of political parties, by media and opinion makers, and labeled as actors of a process of politicization of the judiciary. It started in 2006 when the reform of the judiciary, at a time when the Council enjoyed the confidence of the public and of the judiciary, established with reference to the appointment of heads of judicial offices that seniority was no longer the main criterion for selection. It became only an eligibility requirement to participate in the selection, and becomes relevant only for the choice when two or more candidates are considered equivalent on the level of indicators of professional quality. Now the choice is discretionary, based on the assessment of the candidates' professional abilities, their organizational capacity, their personal experience in relation to the specific post to be filled. The Council has regulated through circular letters, bylaws, how to exercise its discretion in identifying the indicators to be considered. Unfortunately, however, this expansion of discretion in the practical implementation has found a weaker Council due to the loss of the bonds of value and integrity cultivated by the associations of magistrates who, through their political actions, promoted transparent accountability for every choice. Following the 2002 electoral reform, magistrates in the Council are no longer elected on a basis of competing lists and according to a proportional system, but through single preference given to individual candidates. The electoral law, precisely because it is based on a majoritarian system for individual candidacies, has succeeded in breaking the cultural and the loyalty ties of groups that, under the proportional system, put themselves forward with a unified vision and took responsibility for the behavior of their elected representatives. The Italian Constitution provides that council members are not immediately eligible for re-election. The law also prescribes that they enjoy immunity for criminal, civil, administrative and disciplinary liability for the acts performed in the exercise of their mandate in order to guarantee their absolute freedom. The consequence is that the single member is not accountable in any form for the choices made. Once the term of office is over, he or she does not submit of any form of judgment by the voters. Proportional voting of groups was the mechanism for demonstrating the appreciation of the work of the representative as member of the council, or punishing them when they had not provided good performance. Majoritarian voting prevented even this mechanism of political accountability by associations. In this situation, therefore, the individual power of the single members of the council and the permeability of the system to clientelism and opaque relationship increased, as well as illegitimate demands and pressures coming from outside and inside the judiciary to condition their functioning. Therefore, to conclude on the point, the problem in my view is not the excessive power of the associations, but on the contrary, the group's loss of all accountability and thus of the value links that allow the council choices to be transparent. The public debate now on the reasons for the crisis and the remedies to be adopted made it clear that what was really at stake was this model of self-government and the role that, amidst ups and downs, the High Council played in building a democratic judicial system and in guaranteeing independent jurisdiction. In spite of the obvious conflict with the Constitution, which provides for the judicial members to be elected by all ordinary magistrates, the drawing of lots as a method of selecting the councillor has been strongly proposed by commentators from outside and even inside the judiciary. On the other hand, there is a strong opinion by judge and public prosecutor themselves in support to the return back to the seniority as the main criteria to appoint the heads of the office, for its objective, predictable and non-discretionary nature, in order to safeguard the judiciary from external and internal influences on the decision by a council. We have on the floor radical proposals for reforms aiming at reducing the independence of prosecutors by changing their status of magistrate and consequently splitting the High Council. There are proposals for significantly reducing the prerogatives of the High Council and even the composition, questioning the majority of judges and public prosecutors. I stop to respect the time. For any other information, I will attend the debate. Thank you very much.
Thank you very much, Gabriele. And now I give the floor to Professor Bartosz Wolodkiewicz.
Okay, I'm happy that we're having this conference today because the condition of a tribunal established by law had for years been overshadowed by other elements that constitute the right to a fair trial. In previous presentations, we saw how the process of nomination looks in different EU member states, but it also shows how that this standard, there are sometimes breaches of this standard, that in some cases it is being eroded, and this leads me to consider whether the effects of the outcome of breaching the right to a fair trial can have cross-border impact, meaning that a breach of the standard in one member state affects the judiciary in other member states. In practice, this element did come up in cases regarding the European arrest warrant, in EU arrest regarding EU arrest EAWs. There was the question whether the court deciding to surrender a person might refuse to surrender that person if it is aware of irregularities regarding the independence of the judiciary in the issuing country. This has been already addressed in the case law of the European Court of Justice, but similar things also exist in civil cases, and this is what I would like to focus on in my presentation. I would like to examine, first of all, whether the court in a member state can determine the legitimacy of the court in the issuing country. So my point of reference is various EU directives and regulations on the recognition and execution of judgments and possible breaches of the right to a fair trial, specifically tribunal established by law.
I need to start by emphasizing the fact that has been raised before, the differentiation of the appointments of judges and the fulfillment of the criterion of a tribunal established by law is in and by itself not of great concern. It does not require action so long as the minimum standard is met, the standard under European law and the European Convention of Human Rights. And in this context, I refer to Article 19(1)(2) TEU, which suggests that the member states must establish such legal remedies that are necessary to ensure effective legal protection. Now, effective judicial protection must be granted by an independent court under the Charter of Fundamental Rights. The European Court concluded that the judicial appointment should exclude any doubt in the mind of the general public as to the impartiality and independence of the judges. Now, if you consider trans-border or cross-border cases, this standard defines a guarantee which underlies the mutual trust in the judiciary among the member states. In civil as in criminal cases, where standards regarding the enforcement of judgments, judicial review, the transfer of judgments. This is all based on the fact that the member states comply with the same standards in a similar way. This is the basis for the trust. The CJEU considers that the assumed compliance with the standard, the assumed or presumed mutual trust must not be controlled by the member states. However, and this is what the court adds, with or subject to exceptional cases. Now, what does it mean, exceptional circumstances? Under what conditions may the courts of a member state examine whether the guarantee of a court established by law is provided in the member state? Now, to address this question, I'd like to start by referring to the case law of the European Court on the European arrest warrant, as well as comments, legal comments, which suggest three possible options when you consider how to resolve issues that arise when a court in a member state of the judgment is not a court established by law. The first option is the most conservative, and it refers to the general assumption that the courts in general must not decide whether or not a judgment comes from a court. So they cannot test this standard as long as Article 7(1) of the Treaty on the European Union is not breached. So in this first conservative option, the breach of a standard cannot be tested or examined until the member states' rights are suspended in judicial cooperation in civil matters. Concerning European arrest warrants, this is the option rejected by the CJEU, which concluded that presumption of confidence in the member state's legal system can be rebutted by information on systemic problems with the independence of the judiciary in a member state, and the European Court has upheld this position regarding European arrest warrants in the face of actual risk to the right to a fair trial to a party. Regarding judicial independence, both in civil and criminal matters, the court decided that for civil matters, civil cases, Article 70 EU is not necessary to be evoked. Now, this takes us to solutions that are proposed directly in reference to judicial cooperation in civil cases, many of which are based on the classic instrument of handling the proceedings before a court in the member state of origin regarding public order. Article 45(1) allows for rejection of exercise of a judgment on grounds of public order. The question is, may public order in a member state refer to standards which are guaranteed in the Charter of Fundamental Rights or European law in general? In cases far removed from rule of law, the European Court, has referred to Article 47 of the Charter and the European Convention of Human Rights, which refer to public policy. So public policy or public order can be a criterion used to test whether or not the judgment is consistent with the standards of rule of law in the member state. European standards include the requirement for a fair trial and a tribunal that is established by law. Now, the problems that arise in the application of the principle of public policy are due to the fact that this instrument must be evoked by the parties. So the burden of referring to public policy is on the parties. So this is not an automatic system. The test has to be performed in any case. The case law suggests, as supported and endorsed by recent commentators, that the approach should be different and based on the simple circumstance that the judgments are issued by courts. Then what is a judgment and what is the court that issued a judgment to make it eligible for exercise in another or enforcement in another member state? If you look at the free flow of judgments and judicial cooperation in civil matters, the European Court in its case law clearly stated that a judgment that may be recognized or enforced has to be passed by a tribunal established by law in an adversarial procedure. So the judgment must be passed by another court of another member state in line with a specific standard. Now, this approach, which is quite innovative, has no clear legal basis. However, the presentations delivered today, the comments raised concerning the crisis of the rule of law, suggests that perhaps some instruments in judicial cooperation in civil cases face a loophole. We cannot, well, the breach of the standard goes unanswered. So the formal approach to the concept of court, if a judgment is passed by a body called court in a member state, must be considered enforceable because it comes down from a court. Now, this may have a legal basis in the case law of the CJEU under Article 267 TFEU. So, at first sight, case law on the question, what is a court, referring a question, Article 267 TFEU, that could be a formal criterion to test whether a body is a court. In C 13220, based on a question referred, the court decided that a body may be considered a court irrespective of its composition, that the Court of Justice cannot test that to consider whether or not the referring court is a court. Now, the European Court also raised 2 points where this standard may not, or this principle may not be fulfilled. First is that if there are other
wynika, że sędzia orzekający w składzie orzekającym nie jest sądem niezawisłym, to można przyjąć, że to domniemanie jest.
The principle well, the second circumstance concerns other criteria, which may also be. The speaker is speaking much too fast, reading his paper. Can he please be asked to slow down because this is impossible? Thank you.
Are asking if you could speak a bit slower.
Okay, slowly.
Oh, sorry.
Okay, no problem at all. Okay, so po polsku, dobrze. It would be easier now, I know, but I will finish my presentation in Polish. Okay. Formalne podejście do pojęcia orzeczenia.
Formal consideration of judgment. Article 47 of the CFR TFEU allows us to step down from this standard in some specific circumstances. The question is, could this be automatic? So every time a judgment is passed by a court which is not compliant with the standard, may the judgment be rejected or refused for enforcement. The case law on the European arrest warrant suggests that the European Court, does not want this system to be automatic. The consequences of any breach of judicial independence or the requirements for a tribunal established by law must be tested in 2 steps. In the first step, general, tests whether there is objective, reliable information demonstrating that there is a real risk of a violation of the right to a fair trial. In the second step is whether this affects the case pending. So the point of reference is whether the guarantees or the standards are being breached and whether that affects the case before the court. So this protects the balance, important, especially in civil cases where there are disputes between 2 parties. A judgment which does not meet the standard could be refused, and that is a risk even greater than in criminal cases. However, if we assume that the test cannot be automatic, that it must be a case-by-case test, then the third option, the innovative option, is very similar to the good old clause of public policy. Do we really need to invent a new instrument? Perhaps we could consider that all the case law concerning a tribunal established by law sets the direction based on the principle of public policy, with the possibility of individual assessment and the instrument widely used in judicial cooperation in civil cases. To conclude, the violation of the guarantee of a tribunal established by law runs a risk for the parties to proceedings in the first place. The consequences may be cross-border and cannot be considered under the principle of public policy. If so, they will be harmful to the parties because a judgment may not be recognized or enforced. So we have to prevent such infringements, and this is the topic of the third panel discussion today. And I will stop here before we talk about how to prevent breaches and infringements ever before they become cross-border in nature.
Thank you very much. With the agreement of the organization, I think we still have at least 5 to 10 minutes of debate. I'm in the hands of the organization, so.
We have to start the third panel at the hour we planned.
Okay.
So maybe up to 5 minutes, yes, if there's any question.
Okay.
Okay. Maybe.
And maybe we can have the, if there.
Maybe.
If there are more questions, we can have it after the last panel, but maybe we can get 1 or 2 now and then,
okay, so.
as you wish.
Yes, thank you. Muito obrigado e obrigadinho, Mr. President. I've got a long question, but it's unpolite this time. Only one question. Don't worry about it. For me, it's very strange, very rare, when this kind of debate, in general, everybody speak about political interferences. I am 69 years old. After 44 years working as judge, I never have received any political interferences. I understand that we are living now in Poland, I understand. But in general, nobody speaks about another kind of interferences. Powerful people and different activities. People with power, magazine, newspaper, social network, private company, the people with power, no the working class. I am not talking about this. About the people with power, real power, not only official and political power. And my question is, do you think in general only the main risk is about political interference or depend on the country? Because in general, the judge finally is alone with his or her responsibility, alone with the evidence and the computer. And in that moment, you know perfectly when you are writing in favor of some judges, in favor of your public image, in favor of your future, in favor of your salary or your promotion, etc., etc. And my question is, it's very important to work in order to arrive the independence, the real independence of all kinds of judges, because it's a permanent objective, permanent target, permanent goal. And little by little, it depends on you, your responsibility about your ideology, your religion, your prejudice, and all kinds of interferences. For me, it's very important to highlight this kind of fight, permanent fight, all kinds of judge in a rule of law. I don't know if the question is clear. Muito obrigado e obrigadinho, Mr. President.
Better to have one question, because then if we have time, then we can have more questions in the third panel. But please.
Questions in Polish, we need this.
This will be a short question because the previous speaker raised a very important issue in the context of interpreting the public policy clause. This is something that did come to mind because the European Union is not countries within the European Union, but also countries outside the Union. And now the public policy clause is a political interpretation, because when something is political, it doesn't mean that it's good or bad. It's just that's just the way it is, and you need to call it by its name. And if in these bodies that are meant to appoint judges, if judges are to be in these bodies, which elect judges, which appoint judges, the question how these judges themselves are selected. In Poland, we have a difficult situation at the moment, and the interpretation of provided by Strasbourg is not hard law, and any. But despite the difficult situation we have, one accusation made, although this has not been popular, and this wasn't popular, and it wasn't seen as okay to discuss in the previous arrangement of the previous system, the National Council of the Judiciary in Poland did not take into account, when selecting its members, the self-governing bodies, so having the judges be representative. Most of them were judges at regional courts, and the changes that took place in the meantime meant that in the regional courts you had judges who were experienced, there were fig leaves, so-called official fig leaves or token judges from lower courts, but they weren't represented. So, any changes, so how these judges are to be appointed, if these are to be judges representing the community. With politicians, they're at least transparent, but with the appointment of representatives of civil society, I fail to see any such mechanism.
Questions, and then if there are more questions, we will proceed in the afternoon. I will start by this last one, which had a specific addressee.
Dobrze, odpowiadając na kwestię, która się...
Yes, to respond to the question that came up regarding the public policy clause, I wouldn't say that this interpretation diverts from what we know, is inconsistent with what we know about the clause. It has basic standards and principles that are in Polish law and other sources of law that are domestic law binding in a court, in the court that adjudicates. And the public policy in procedural terms, from the perspective of Polish court, also includes the Polish constitution, the right to a fair trial, a trial before a tribunal established by law. So it is a collective, it's an aggregate approach to these standards, where we have Article 47 of the Charter of Fundamental Rights, Article 7 and 6 and the Polish Constitution, all of which contribute to a standard whereby we expect the court to be impartial. Any breach of this standard, regardless of whether it's a ruling from a member state of the European Union or a third country, needs to be recognized by the court in the interest of the parties. The parties and the right of the parties for the court to be independent and impartial needs to be respected, and this is the element that leads us to ask whether the judgment was laid down, was made by a court that was established by law, and that's how I would understand public policy.
For the sake of our lunch, I would postpone the answer to the question that was previously asked, because it touches some points that I think will be addressed in the third panel, because what was referred to as the influence of other powers, not just the political power, also has to do with the need to change it, to reconstruct the system afterwards, because it touches a lot of topics that were addressed by speakers, not only from this second panel, but also from the first, when we talked about culture, eating rules, and the socialization of the judiciary. One important thing that I think we can reflect on in the second panel and the debate that hopefully will follow, we have heard a lot about countries that have established judicial councils, in which judicial councils are not working as they should. And we have heard about other countries that do not have judicial councils and where things are working. But we also heard some warnings of this is working now, but maybe in the future, if there are some political turmoils, maybe they can eventually not work properly if the system doesn't have guarantees. And that's very important for what we'll be discussing in the afternoon on the reconstruction. And that may also have to deal with the question that was asked about the influence of other powers, not just the political one. So I will postpone the debate on that question to the afternoon, and have a nice lunch all. And apparently we have to start at 1:30 sharp.
So we have to be on time here. And if anyone is interested in the certificate, you can have it at the reception desk.
Thank you.
Yeah.
I think we should start our panel because we really need to be on time. There is the Justitia's assembly today and some our participants need to leave at 3 o'clock. That's why we really need to follow our schedule. Yes, it's ready. I'm really glad to be moderator of this panel. After these two panels where our panelists described the standards of appointments of judges in Europe and the situation in other countries, it's so interesting to see how the situation looks like in countries which are struggling now at the moment and how it looks in Denmark, where there was a terrific change of the system some time ago, and how was it possible and how did it work out? So let me start with Orhan Karabachak, who is a Turkish judge in exile. He's also representative of YARSAF, of Association of Judges, and it's my honor to have you in our panel.
Hello, it's my true honor and privilege being here before such distinguished and brave judges. And I will try to show you one of the worst examples. Let's look at how the government established, built its own judiciary. The biggest obstacle to the authoritarian leader who is elected and comes to the power through democratic means is the legal order and its guardians. The first item of their agenda is to make judiciary and media not obstructing but helping the construction of the new regime. The judiciary should become instrumental in time and enter the service of one man. This extraction, this summary from our own experience, not only observation, but we lived, we faced what happened over the time in Turkey. Authoritarian leaders are taking steps in construction of one-man regime as if there is a worldwide written handbook. You may call it playbook. I will cite some remarks regarding with the discourse developed over the time in Turkey. How the authoritarian leader built its own judiciary. First bundle of action, demonize the judiciary. His remarks: no institution is immune to criticism. Judges are above the nation, they cannot make arbitrary decisions. Judiciary should not be allowed to come under anyone's influence in this country. Judiciary cannot decide against the will of the people. Judiciary does not turn into a tool in the hands of opposition which hinders the power of people. The caste system in judiciary must be ended. You can add many more remarks. This constantly repeated discourse embodies some selected court decisions. For example, decisions that are not welcomed by majority of the people. These kinds of cases are chosen by the government to show that the judiciary is the main obstacle in front of the investments. They try to establish a perception between economic development and judiciary. The second, but while all this is being done, the high judiciary is targeted, not the first instance courts. Second bundle of actions. Yeah, premises. Then the leader starts to make some promises. First, like, let's make a nation's constitutions, not the soldiers. Many diseases in public sector will be cured with the referendum of judiciary. Justice will become easily accessible, and cases are concluded in a much shorter time. The quality of judicial services will be increased. The perception that there's a strong link between reform and economic development is disseminated simultaneously. And we have third bundle of actions, divide and rule. This is inside of the judiciary. This bundle of actions should be done simultaneously with the first and second actions. First, to get the sympathy of judges, the government makes huge increases in the salaries of judges. We had this in Turkey. And enact a law on pardon all disciplinary sanctions of the judges and promote judges close to the government. And the internal part, one of the internal parts of our judicial destruction is the establishing a judicial association by the government in the judiciary, like a Trojan horse. In order to, this is obvious fact that we are a part of society and we have certain political views. In order to prevent solidarity among judges, it is necessary to categorize judges like conservatives, socialists, liberals, nationalists, with the huge support from the intelligence agencies. And the last bundle, and this is legal action, referendum and abusive constitutionalism. Appeal to referendum for judicial reforms, prepare amendments as a package by adding some items. No one would say no to the referendum. If you put the referendum package regarding only with judicial referendum, judicial construction or amendments, it may not work well for the government. Then put some items, those are the attractive, appeal to all people. This happened in Turkey. Here I want to quote, democracy may serve as the means by which an organized cabal or subgroup in society seizes the reins of government power, then utilizes the law to advance its particular agenda while claiming legitimacy conferred by democracy. Let's quote one more. While referenda might promote civic responsibility, they might also be abused as a tool for populist movements seeking crass simplification of policy choices. Then why do autocratic leaders appeal to the referendum? Yeah. Referendum is, besides serving direct democracy, referendum is one of the means of legitimizing the power of autocratic leaders, especially when it comes to fundamental change in the constitution. And we can describe the referendum, as was the case in Turkey, like an instrument of choice by representative government, the recourse of prince, universal acclamation of the autocrat, power consolidation of referendum, a favorite tool of tyrants and dictators seeking to legitimize and sustain their rule, and as a political weapon. And referenda have served in Turkey to take over of the judiciary by the ruling party. That's why the demand for constitutional amendment has always come from the government. And let's look at the facts in Turkey. One of the most important referendum was 2010. Some of the items included in the referendum package contained provisions that no one would say in terms of democratization of Turkey. That's why at that time European institutions appreciated the amendments in the constitution, but the core of the referendum was structural changes in the judiciary. Yes. Through the referendum 2010, the number of members of Constitutional Court was increased and selection method was changed, and Judicial Council members was increased from 7 to 22, and 15 of the 22 members were elected by the judges and prosecutors themselves. At first glance, it may sound good for the judges to elect their own members. It turns out that this is done to prepare the ground for polarization among the judges. That's why at that time Yarsav initiated a campaign, no to the referendum. And between two referendums, there are some developments in the number of members of high courts. As you see, there are huge increases in the number of members of high judiciary. And July 2016, despite everything, it is not possible to satisfy the ambitions of the dictators. For this reason, coup attempt of 15 July 2016 was described and welcomed by Erdogan as a God gift. Because although he applied exactly what was written in the handbook, or you may call playbook, he still couldn't fully grasp the judiciary. There were brave judges who still believed in democracy and rule of law. Therefore, 2,840 judges and prosecutors were dismissed over a night, while soldiers were still on the street. No single action was taken against this single soldier, but the judges. And even the name of the prosecutor who died months ago was among those who were dismissed. After the coup attempt, first of all members of the Supreme Court and Council of State their tenure were terminated. And then some of them were chosen again and reappointed. And one of the important amendments was the exam-based score requirement to be admitted to judgeship was removed. It was important after graduation from school, you can automatically be eligible to be appointed as a judge in Turkey. Now it's only interview done by the high bureaucrats of the Minister of Justice. And 2017 referendum, it was a total destruction of judicial independence. I try to picture the current state of Turkey as seen interestingly, the government wanted to remove the wording high from the beginning of the name of the council. And then number of members reduced again. You see, the government has been playing the numbers through the referendum. It was important. And now current situation is the 7 members are appointed by the parliament, dominated by the ruling party. 6 are directly selected by the president, including Minister of Justice and Undersecretary. And as seen, step by step, the government built its own judiciary. And then what happens when you don't have a tribunal established by law? Some known results. I will go very quickly. It's the recent indexes. Those are like rule of law index, now one of the worst, as you see, 135, and the global democracy index ranking 103, one of the worst. And the Freedom House report, Turkey was declared not as a not free country. And now thousands are in prison, either insulting the president or being a member of terrorist organization. Hundreds of thousands of people were laid off from their jobs, including the academics for peace. Torture has become a common practice. Thousands of people had to leave their own country. Selahattin Demirtas, the leader of the second largest opposition party, has been in jail for years for purely political reasons. Court decisions to appoint trustees to municipalities and removal of elected mayors, even in large cities. European Court of Human Rights decisions are not implemented in some cases, you see. And Constitutional Court decisions also have not been implemented. And European Court of Human Rights found a violation in our cases, I am one of them, 847 members. Our initial arrest was completely unlawful, declared by the court. And UN Working Group on Arbitrary Detention found arrests of 43 applicants arbitrary. Actually, there have been a few people appeal to the UN body. And one of the worst, Council of Europe infringement procedure was initiated. ENCG suspended the Judicial Council's observatory membership. Justice Academy's membership was suspended. Venice Commission on many occasions declared the unlawfulness in Turkey. Reports of UN special reporters and PACE, Parliamentary Assembly of European Council, decided that back to monitoring procedure. It's a huge fallback in Turkish history. And another solution, and European Parliament resolution. Yes, I quote, the current Turkish government has deliberately demolished an aspirations of reopening the EU accession process in the present circumstances. It shows how terrible the current situation is. And also the last shot came from Medel and Turkey Tribunal and the law firm in Belgium submitted a communication together to the Office of Prosecutors of International Criminal Court concerning the situation in Turkey. And last, the destruction of this dark period will be only understood years later. This, we don't know, actually, sociological, psychological, educational, economic, and environmental consequences. I hope not be so worse. Thank you so much for listening to me and your patience.
Thank you so much, Orhan. It's always very moving when you report the situation in Turkey. Let's move to Lev Keshakevich, the judge of the Supreme Court of Ukraine and also member of the Ethical Council of Judges in Ukraine. Anna Adamska-Galant is going to translate Lev from Ukrainian to English. So the floor is yours.
Thank you. Добрий день. Шановні учасники заходу,
Good day, all the participants of the event.
шановні учасники конференції, судді європейських країн, члени польських та інших країн Європи, асоціацій. Від себе особисто та від імені голови Верховного суду князя Всеволода, усіх суддів України, хочу подякувати за підтримку та допомогу як у війні з російським агресором, так і наближенні судової системи України до європейських стандартів, а також України до Європейського Союзу.
Respected participants of the conference, honored judges, members of Judicial Association of European countries, on behalf of the President of the Supreme Court of Ukraine, Vsevolod Knyazev, on behalf of myself and on behalf of all judges of Ukraine, I'd like to express my gratitude for support for Ukraine and its fight for democracy, and also for support for closing the Ukrainian legal system to the EU one.
Україна сьогодні перебуває на передовій з російським режимом, на передовій боротьбі з російським режимом, диктатурою і тоталітаризмом.
Ukraine is continuing its fight against Russian regime, against dictatorship, against totalitarianism.
А наші люди, в тому числі і судді, гинуть за те, щоб війна не поширилася далі у Європу.
Our people, including judges, are dying for this war not to extend beyond the borders of Ukraine.
Україна бореться не тільки за свою територію, життя та безпеку громадян, дотримання прав людини, а й за весь демократичний світ і за верховенство права.
Ukraine is fighting not only for its citizens, for its life, for its territory, but also for the whole democratic world, for the rule of law.
Війна в Україні триває більше року, але не дивлячись на постійні ракетні обстріли, відсутність електропостачання, тривоги, судова система не зупинила своєї роботи.
The war is lasting more than a year, but despite the electric cuts, despite the shelling, despite the alarm rate, the judicial system is continuing operation.
Судова система продовжує свою роботу, здійснює судочинство. Протягом року судами України розглянуто 2,5 мільйони справ.
The judicial system is continuing working, the justice is being delivered, and during this year, more than 2.5 million of cases were dealt.
Зокрема, Верховним судом було розглянуто 90 тисяч справ.
In particular, the Supreme Court of Ukraine decided on 90,000 cases.
Жахи війни торкнулися і нашої судової спільноти. Є численні випадки загибелі суддів, захоплення російським агресором наших суддів в полон, знищення житла суддів.
The attacks of Russia also affected judges in person. Some of them were killed, some of them were taken hostages. Their houses, buildings were destroyed.
99 приміщень судів зруйновано або знищено.
99 court buildings were destroyed or ruined.
На жаль, 54 суди перебувають на окупованій території.
Unfortunately, 55 courts are still on occupied territories.
Завдяки міжнародним партнерам, зокрема і організації «Право Justice», дякую пані Анна, за допомогу. Триває процес відновлення судів в Україні.
Thanks to support of international partners, including Pravo Justice project, the process of renovating of the judicial system in Ukraine is continuing.
54 судді змінили мантії на військову форму.
54 judges changed the robes for the military uniforms.
Зараз знаходяться на передовій боротьбі з агресором.
And they are fighting on the front line for the state.
25 мільйонів євро перераховано офіційно суддями на потребу Збройних сил України.
Judges transferred more than 25 million euro for needs of the army of Ukraine.
Хочу зазначити, що для наближення перемоги над російським агресором та вступу України в Європейський Союз суддівська вся спільнота бореться на своєму фронті.
I want to underline that to approach the victory over Russia, but also to make judicial system of Ukraine closer to the European standard. The judicial system is fighting on its own field.
Я хочу зазначити, що цей фронт не є менш важливим, оскільки наближає вдосконалення нашої судової системи, і воно наближає до європейських стандартів та до вступу України в Європейський Союз, і це є вимогою Європейської
I want to underline
Союзу.
that this front is equally important because not only it is making Ukrainian judiciary closer to the European Union, but it also make the country closer to the European Union membership.
Мій виступ буде складатися з двох частин. Буде стосуватися досвіду України щодо конкурсу до Верховного суду, а другого щодо функціонування етичної ради.
My presentation will be divided into two parts. The first one will refer to the competition to the Supreme Court, and the second part will deal with the operation of the Ethics Council.
Хочу зазначити, що в обох процедурах я особисто брав участь. В першій процедурі до Верховного суду як конкурсант, а в випадку етичної ради мав честь очолити етичну раду.
I want to underline that I participated in both procedures to the Supreme Court as a candidate running for the position and in the Ethics Council as the head of the Ethics Council. I had the honor to do so.
Зупинюся на конкурсі до Верховного суду, який тривав з листопада 2016 року по липень 2017 року.
First, I concentrate on the competition to the Supreme Court, which was conducted from November 26 till July 2017.
У 2017 році було проведено істотну реформу касаційних судів України, оскільки на той час існувало 4 суди. Це був Вищий спеціалізований суд України з розгляду цивільних і кримінальних справ.
In 2017, there was a serious reform of the Supreme Court of Ukraine. Till then, the Ukrainian Supreme Court was composed of 4 separate cassation courts. First, dealing with civil cases. Second was
Вищий адміністративний суд України.
it was High Administrative Court of
І
Ukraine,
Вищий господарський суд України.
High Commercial Court,
І це не все, і ж був ще окремо ще й Верховний суд України.
and except of this, there was the Supreme Court of Ukraine.
З 15 грудня 2017 року функціонує один суд – Верховний суд.
Since 15th December 2017, there is only one Supreme Court.
Таким чином виконано багаторічні вимоги і рекомендації Венеційської комісії та Ради Європи.
In this way, the recommendations of the Venice Commission and the Council of Europe were implemented.
У складі Верховного суду функціонують 4 касаційних суди – це адміністративний, господарський, кримінальний та цивільний.
In the composition of the Supreme Court, there are like 4 chambers, administrative, civil, commercial, and criminal.
Вперше в Україні в історії було проведено відкритий конкурс на посади суддів Верховного суду.
It was the first time in history of Ukraine that an open competition for the Supreme Court judges was conducted.
Усі учасники конкурсу були в рівних умовах.
All participants of the competition participated on the equal conditions.
Вперше на рівні зі суддями в конкурсі змогли брати участь і адвокати та науковці, які мали стаж, 10-річний стаж.
It was the first time in the history that equally with judges, also lawyers, advocates, and academics could apply for a position of the Supreme Court judge. There was a requirement of 10-year experience.
На першому етапі конкурс був на 120 вакантних посад у Верховний суд.
The first stage of the competition was for 120 positions in the Supreme Court.
– 625 кандидатів були допущені до конкурсу.
There were 625 candidates who were admitted to the competition.
Ви бачите на діаграмі окремо щодо відсотковому відношенні, співвідношення всіх учасників, які брали участь в конкурсі.
You can see on the slide the proportions of all the participants of the competition.
Бачите, що найбільша частина було суддів, 70% було суддів. Це були судді першої, другої та третьої інстанції.
The biggest part, these were judges, 70%, judges from the first, second, and third instances.
Умовно, конкурс можна поділити на 5 етапів. Перший етап проводився професійний іспит, в якого входило складання тесту анонімного на знання законодавства.
There were 5 stages of the competition to the Supreme Court. The first professional exam, which was related to professional knowledge.
А також виконання практичного завдання, тобто написання рішення Верховного суду відповідно до обраної спеціалізації.
There was also a practical task, so there was a need to draft a decision of the Supreme Court falling under the selected by the candidate jurisdiction.
Хочу сказати, що як учасник цих перегонів було забезпечена повна рівність всіх учасників конкурсу, які брали участь, оскільки в цей конкурс відбувався анонімно і прізвища тільки знали після оголошення результатів.
I want to underline that all the competitors had equal conditions because the competition, this part was conducted in anonymous way, so the result of the written part were known only after.
Другий етап – це були визначення психологічних спроможностей для здійснення правосуддя Верховному суду.
The second part, it was psychological testing of ability to deal as a judge of the Supreme Court.
На цьому етапі судді складали психологічні тести і проходили співбесіду із психологом.
The candidates had to go through a psychological testing and they also had like interviews with psychologists.
Третій етап передбачав вивчення досьє і мав на меті здебільшого з'ясувати доброчесність та кандидатів та відповідність етичним стандартам.
The third part consisted of analysis of the documents of judges, and it also included the questions of integrity and ethical standards to be met by them.
На четвертому етапі із кандидатами проводилися третьому етапі, перепрошую, на третьому етапі ще було вивчення досьє кандидатів і на четвертому етапі кандидатам проводилася співбесіда і ураховувалися даних їх досьє.
During the fourth stage of the competition, there were interviews with the candidates, and there was also reference to their dossier.
Хочу сказати, що на цьому етапі вперше була допущена громадськість у вигляді громадської ради доброчесності, які мали право брати участь у засіданні.
This is also important to underline that at this stage the civil society was admitted through a public integrity council. Its members were allowed to participate in the interviews.
Співбесіди транслювалися з кандидатами онлайн, і їх міг проглянути будь-хто.
Interviews were broadcasted online and everybody could watch them.
П'ятим етапом було пленарне засідання, на якому затверджувалися вже результати цього конкурсу.
The fifth stage, it was already the plenary session of the High Qualification Commission for Judges, which was deciding on the results of the competition.
Таким чином, за результатами першого конкурсу, Вищою кваліфікаційною комісією суддів було сформовано рейтинг зі 120 кандидатів, і були вони рекомендовані до заняття посади судді Верховного суду.
On basis of the results of the competition, the High Qualification Commission formed a list of 120 candidates who were recommended to the High Council of Justice for appointment.
Я, як безпосередній учасник цього конкурсу, також з гордістю можу сказати, що очолив рейтинг в касаційному кримінальному суді і був обраний суддею Верховного суду.
As a participant of this competition, I am proud to say that I was selected as a judge for a position of a judge of the criminal chamber of the Supreme Court.
Аналогічно була застосована процедура і для другого добору, і в результаті якого було обрано ще 70 суддів Верховного суду у 2019 році.
The same procedure was applied in 2019 when there was the second round of filling competitions to the Supreme Court, and then 71 judges were selected.
Щодо роботи етичної ради, яку маю честь очолювати, я також зупинюся зі слайдами попробую продемонструвати на роботу етичної ради коротко.
Now I have an honor to present the work of the Ethic Council that I am presiding, and I will use the slides to do so.
В липні 2021 року, відповідно до закону України, було внесено зміни до закону України про Вищу раду правосуддя, була утворена етична рада.
In July 2021, the law on amending the law on High Council of Justice was adopted, and the Ethic Council was introduced.
Яка мета утворення етичної ради? Мета була одна – це сприяння органам, що обирають членів Вищої ради правосуддя у встановленні відповідності кандидата на посаду члена Вищої ради правосуддя критерію професійної етики та доброчесності.
The goal of the Ethic Council was to provide support for the bodies competent to elect or appoint members of the High Council of Justice in assessment of the corresponding the candidates for the High Council of Justice with professional and ethical standards.
На етичну раду було покладено два основних завдання. Перше – це проведення одноразового оцінювання вже чинних на той час членів Вищої ради правосуддя. А друге постійне завдання – це проведення оцінювання кандидатів на посаду члена ВРП.
The law imposed two tasks on the Ethic Council. The first task was to assess the then sitting members of the High Council of Justice. So it was like one-time job, while there is a continuous task of the Ethic Council to assess candidates running for the High Council of Justice in case when there is a vacancy.
Було сформовано відповідно до закону, сформовано перший склад етичної ради.
The first composition of the Ethic Council was composed in accordance to the law.
Хочу сказати, що саме на перший склад етичної ради покладено виконання першого завдання – це разове оцінювання діючих членів Вищої ради правосуддя.
Only the first composition of the Ethic Council has had this task to assess the sitting members of the High Council of Justice. This one-time job, as I said.
Хто ввійшов в перший склад етичної ради? В перший склад етичної ради, відповідно до закону, входять 3 судді, рекомендовані Радою суддів України.
The first composition of the Ethic Council consists of 3 judges selected by the Council of Judges of Ukraine.
І 3 міжнародні члени, рекомендовані міжнародними організаціями, які працюють в Україні.
And 3 experts recommended by international organizations that work in Ukraine.
Таким чином, Радою суддів було рекомендовано 4 члени етичної ради, але відповідно до закону перший, хто обрав по рейтингу, тобто діючі 3 члени етичної ради, які зараз у вас на слайді.
So to the first composition of the Ethic Council, the Council of Judges recommended 4 candidates, and 3 of them are the winners of the selection, and you can see the pictures on the slide.
Це 2 діючі судді, це суддя Верховного суду і голова етичної ради – це я, і є суддя з апеляційного суду, а також суддя у відставці.
There are 2 acting judges, Lev Kishakevich as the head and judge of the criminal court in the Supreme Court, judge of the Court of Appeal, also acting judge, and 1 retired judge from Commercial Court of Appeal.
І від міжнародних організацій були обрані сер Ентоні Хупер, це суддя апеляційного суду Англії, Роберт Корді, суддя Верховного суду штату Массачусетс, та Лавлі Перлін, колишній генеральний прокурор Естонської Республіки.
And international donors selected Sir Anthony Hooper, retired judge of the Court of Appeal of England and Wales, Robert J. Cordy, retired judge of the Massachusetts Supreme Judicial Court, and Lavly Perling, former Prosecutor General of Estonia.
Хочу зазначити, що цей перший склад, термін його каденції – це 6 років.
I want to underline that the term of office of this first composition of the Ethic Council is 6 years.
В наступному складі і постійному вже в подальшому 3 міжнародних членів замінять 3 3 представники – це від Ради прокурорів, Ради адвокатів та Національної академії наук.
In future, for the next composition of the Ethics Council, these 3 members will be presented or will be nominated by the Council of Prosecutor, Council of Advocates, and Council of Academia.
Хочу поділитися досвідом про те, що була робота етичної ради з початку, вона була узгодженою, не дивлячись на те, що були 3 українські члени і 3 міжнародні.
The complexity of the work of the Ethics Council resulted from the fact that there were 3 Ukrainian and 3 national experts.
Таким чином, була створена етична рада в листопаді 2021 року.
The Ethics Council was formed November 21.
В кінці листопада. І ми за 2 тижні розробили методологію, регламент і розпочали свою роботу вже 1 грудня.
Within 2 weeks we worked out the rules of procedure, methodology, and on 1st December we started working.
Фактично ми розпочали оцінювання, ми оголосили про початок оцінювання діючих членів ВРП 8 лютого і вже стикнулися з шаленим опором осіб, які не хотіли вдосконалення судової системи України.
On the 8th of February, we launched the procedure of vetting of sitting members of the High Council of Justice, and then we felt this huge resistance from their side, people who didn't support judicial reform in Ukraine.
Фактично ми провели 2 інтерв'ю офлайн до війни.
Till the start of the war, we conducted 2 interviews online. Offline.
Офлайн. І, на жаль, в нас все ділиться до війни і після війни, після російської агресії. І після російської агресії етична рада не припинила свою роботу і не зупинила свою роботу і продовжила її.
Unfortunately, everything is divided before the war and after the war. After the war, the Ethics Council has not stopped working, it continued its operation.
І ми продовжили онлайн інтерв'ю. І в зв'язку з війною ми не транслювали їх для того, щоб російському агресору не надати інформацію щодо, яка може бути використана проти прав та прав учасників співбесід.
We conducted interviews online. They were not broadcasted, not to create security risk for candidates running for the High Council of Justice.
Таким чином, ми справилися з першим завданням, провели оцінювання діючих членів Вищої ради правосуддя.
We finished the task to evaluate sitting members of the High Council of Justice.
І зараз фактично вже і закінчуємо формування списку для того, щоб повністю була сформована Вища рада правосуддя.
And now we are finalizing the list to complete formation of the High Council of Justice.
Коротко скажу про те, що нами було проведено за цей короткий період, більше року. Фактично нами проведено з врахуванням війни 131 кандидат взяв участь в конкурсах, усіх конкурсах.
During this whole year, there were 131 candidates running for the position.
Проведено 112 співбесід.
We conducted 112 interviews.
34 особи визнані такими, що відповідають критерію професійної етики та доброчесності.
34 people were recognized as meeting criteria of integrity and ethics.
І 47 такими, що не відповідають.
47 were recognized as not meeting.
В зв'язку з обмеженням часу я ще міг би довго говорити про досвід і хотів би подякувати всім ще раз за допомогу у боротьбі з російським агресором та вдосконалення судової системи України.
Because of time limit, I will close now. And once again, I would like to express my gratitude for support for Ukraine in its fight against Russia and in its fight for the rule of law and judicial independence.
Дякую. And now Anna Adamska-Galant, who is wearing 2 hats today. thank you for excellent translation. And could you now... as an expert who consulted reforms in so many countries, you have broader perspective for these problems concerning appointments of judges. So please.
I don't know where's my presentation, if it is there.
Yes, there is one, and I think it should be within.
It is, yeah.
Yeah.
So I just want to add to this what Lev said, that when he said about this resistance from the High Council of Justice, shortly before the war, 10 members of the High Council of Justice resigned. And it was a very difficult situation for Ukraine, because the war started and lack of existing constitutional body involved in judicial independence, it created a lot of challenges for the system. And also one thing, like 2 months ago, I believe the High Council of Justice Ukraine has relaunched, so there is sufficient quorum in the High Council of Justice. And what I also want to say that we really see the difference between the High Council of Justice that is formed as a result of the process that Lev described, comparing to this the previous one. And I will be very short, trying to be straight to the point. I will talk about the perspective from Albania, Ukraine, and Moldova. So these are 3 countries who are applying for the European Union. All of them are received membership status already, and they all have kind of experience with vetting judges. And I think it can be interesting just to see how it was. How it was?
The big one.
I don't know. Can I? This one? Maybe I always have a problem with this kind of stuff. Yeah, so I will just use my laptop. You will not see, but it's not a very fancy presentation in a sense of pictures because, okay. So, yeah. I just wanted to indicate like reasons why there may be a need to involve international experts in the process of reforming judicial system. So first, it's a transitional period. So coming from the point when there was the war, there was a conflict, there is a change of regime. There is a question of defiance of judicial integrity. There is also a question of corruption. And I think that all of these elements are connected with lack of trust. And I can't.
Give it to Michaela.
I really don't know. It's really not working with
Low battery. It's this time of day.
Okay, but I wanted first to speak about Albania very, very shortly. As you know, Albania is also running for membership in the European Union. And in 2016, there was a very serious reform of the constitutional law adopted in Albania, which resulted in launching the process of vetting of judges and prosecutors in this country. And objectively, the tasks didn't seem so big because there are only 800 judges and prosecutors altogether, but it has not been finished yet. So we are now 23, and already the Albanian parliament decided to extend this process. The idea of this process is that there is a vetting of judges and prosecutors in Albania. There are 3 pillars that are to be assessed: professionalism, integrity, and possible connection with the corruption. This vetting is being conducted by Albanian bodies. There is like a special body that is vetting, independent body that is vetting the sitting members of the judiciary. From their decision on removal or dismissal, the person can appeal to the appeal chamber. There are also like special prosecutors. And involvement of international experts is kind of advisory, because there is a group, there is a special mission conducted by the European Union, and international experts are observing the way how the process is conducted. They can issue some recommendations, and I believe Grzegorz Borkowski have much more to say about this issue than me. But the result of this process is kind of cumbersome, because at the very beginning of the process, even the Constitutional Court, which decided that the reform is in line with the Constitution, was almost completely dissolved. I think that there was only one judge of the Constitutional Court who left. Same with the High Council of Justice. And as a result, more than a half of judges and prosecutors from Albania were dismissed or left on their own. So this was the approach in Albania we are following. And when we were preparing the reform in Ukraine, we're also kind of learning lessons from Albania. In Ukraine, I would say that like a turning point to start the judicial reform was the Revolution of Dignity 2013, 2014, the events on Maidan. And then there was a need also to cleanse the judicial system, also because of very low level of trust towards the judiciary. The issue of defiance of integrity by judges. There were some judges who compromised, especially with decisions taken during the Maidan protest. And there was like a pressure from the international community to reform the judicial system in Ukraine. And obviously everything speeded up a year ago when Ukraine was given a status of a member of a candidate for membership in the EU. So we really have to speed up the whole processes. And there were like few ways where international experts were involved. The first time it was the formation of the High Anti-Corruption Court in Ukraine, where we had the High Qualification Commission conducting the selection competition as Lev described. There was High Council of Justice involved for in the appointment process, but there was also a Public Council of International Experts. It was an advisory body composed exclusively from 6 members, international members, appointed by international organizations, who had like an advisory role. They only could have issued opinions. The opinions were not binding, but actually the practice showed that the High Qualification Commission followed the negative opinions issued by the Public Integrity Council of International Experts, and these candidates who were assessed negatively were just kicked out from the list. And also very important, what also Lev mentioned, participation of the civil society through Public Integrity Council that is delivering information about the candidates, that is kind of vetting them through this kind of wide investigation, we can call it this way. The next step, it was this step mentioned by Lev, the Ethic Council, with a task to vet members of the High Council of Justice and candidates for the High Council of Justice membership. So in this moment, in accordance with the Ukrainian law, all candidates running for the High Council of Justice, who are to be appointed by the Verkhovna Rada, Congress of Judges, by the President, they should have like a green light from the Ethic Council. In parallel, in Ukraine is operating also the Selection Commission. And the Selection Commission is a similar body, also 3 judges, Ukrainian judges, and 3 international members. And their task is to vet candidates running for the high qualification of judges of Ukraine. And this is like a very important task, because actually the High Council of Justice already received a list of 34 pre-vetted candidates who, from among whom the members of the High Qualification Commission of Judges will be selected. And there is one more plan or one more attempt to get involved international experts or experts appointed by international organizations in the process of selection of the Constitutional Court judges. And there is already a law adopted in Ukraine which provides for existence of the advisory group of experts, and it will be also a group composed, once again, these 3 judges, 3 members from Ukraine and 3 members appointed by the international community, including representative from the Venice Commission, whose task will be to vet integrity, professionalism and moral criteria of candidates running for the Constitutional Court. And this law is still to be amended. There are some concerns as to the role of the members of this group, because there is always an issue who is to decide. There is the question of sovereignty, but The Venice Commission on several occasions underlined, not only in case of Ukraine, but also Moldova, Georgia, Albania, underlined that in such extraordinary circumstances, when there is such low level of trust to the judiciary, when there is a risk of political interference into the process of selection of judges, involvement of international experts may be necessary. And you know, from the practice in Ukraine, where we already had like 3 bodies with the involvement of international experts, usually, even if the law provided that they have like a decisive vote in the process, usually they did not have to use this decisive vote. It was more like working together and gaining consensus between Ukrainian and international experts. And as I said at the beginning, we really see the progress and change when it comes to the High Council of Justice that has been formed in Ukraine, that already started its operation. We are waiting for the High Qualification Commission, which was not existent since 2019. So it is almost 4 years without the body competent to fill vacancies in the system. So this is like the model, or actually models that have been applied in Ukraine. There is like additional model, I would say Moldova. Moldova is following Ukrainian model when it comes to pre-vetting of candidates running for these bodies like High Council of Justice, like High Council of Prosecutors. I must say that this process only started a year ago, and it's not going as smoothly, I would say, as in Ukraine. Recently, even the Constitutional Court of Moldova decided that some elements of this reform are violating the Moldovan constitution. So we do not know how the process will develop. But generally, these are like possible ways to deal with judicial independence, judicial integrity in time of turbulence. And sometimes I believe that this is like a good solution. So I think that I followed more or less my presentation. I'm ready to answer any questions, if any, and I was trying to keep the time. Thank you very much.
Thank you so much. So do we still have these technical problems? Okay, because now Dorota Zawodowska is going to take the floor, and yes, because Mikael, yes, you.
Mikael has a presentation.
No, he's the last one, according to the agenda. So it's very unfortunate that we don't have access to the slides Dorota prepared, but...
it's fate. I always think that the slides just distract people.
The floor is yours.
All right, thank you. I thought I would have the privilege to close this event, but we've heard today about different systems of judiciary, about different systems of electing judges or of selecting judges. And yes? Ale jaki slajd? Mamy coś. Dobrze. Okay, so it's just the pilot that broke. Okay, so you can see what I have. And we in Poland are at a point where the judicial independence protection system was broken. And it is a failure of state and of the system. And on the other hand, it is our privilege to be able to think of something better, taking the best from the experiences of other people instead of taking the worst, which seems what the government in Poland did. Because it's like, it seemed that our government make a review of all the European systems of selecting judges and chose those elements of the systems that would undermine judicial independence and subordinate the judges to the executive. And that is something that happened in Poland, and something that definitely didn't work So we have the National Council for Judiciary. As Christian Markiewicz said at the very beginning of this conference, this cannot be considered the body that we have written down in our constitution because of the politicization of this body. It is true that Polish constitution does not provide for how the judges to the council should be elected. And that's the failure of the people who wrote the constitution. On the other hand, we have to look at the purpose of the council itself. What is it for? And as it is composed of representatives of the judiciary and of the executive and of the parliament, it is logical that it is supposed to represent the balance of powers and the checks and balances that should exist in any democratic society. And it is not possible if one power chooses 23 of 25 members of the council. So we are truly hoping that we'll be able to change the law, to persuade the politicians to change the law into something better, something that would provide our citizens with the guarantee of an independent court for their own good, because judicial independence is not a value, it's not a privilege of the judges. Because we are professionals and we probably work in any circumstances, but it is the right of the citizens. The citizens have the right to an impartial and independent court, and that's our starting point. It's always the citizen that is in the center of anything that we do, as representatives of the power, the third power. So, going back to my presentation, since we are in a mess, the first thing that we have to do is to clean it up in order to make room for the better solutions. So we believe that as the new National Council for Judiciary is a political body and it follows the political will, it should be reconstructed, which means the extinguishing of the mandates of the judicial members of the council, because they do not represent the judiciary, they represent the political power. And to make sure that the judges in the council represent the judges as they should, and not the Sejm or Senate, we think that it should be proper that there are direct and secret elections to the council from among all of the judges. And there should be full representation of all kinds of courts in accordance with the constitution, because right now there are some types of courts missing, like the military courts or administrative courts. If we could, można zmienić slide. Okay, so right now this faulty system provides for candidates being proposed by 15 judges or 2,000 citizens, but it is still the same who composes the list, so it's not very difficult to find 15 judges among 10,000 who will follow the political will. What we would like to have is that the candidates are nominated by different environments, as you can see in the slides, including a group of 2,000 citizens, and there would be a general voting among the judges to elect the 15 people for the council. And poproszę o zmianę. Also to improve the communication of the judiciary with society, we think it would be appropriate to create a social council, an advisory body to the National Council for Judiciary, and it would be composed of members nominated by legal entities, as you can see, the Ombudsman, Chief Counsel of Science and Higher Education, and also 3 representatives of the NGOs. Well, the project says it's people nominated by the President, but I already heard some NGOs opposing, which is not surprising, so maybe this is negotiable. Our idea is that the judiciary should be owned by the people, not the government, not the politicians, but the people. And in order to have the people have the sensation that they have influence on what judiciary is doing, we suggest we have a social council at the National Council for Judiciary. Poproszę następny. So, to sum up what I've said so far, these are our goals. The council should be depoliticized, it should be effective, it should be closer to the people, and should be transparent, which means that it should be any deliberations should be broadcast, the finances should be transparent, so that there is no room to abuse of power within the council. We've seen it happen with the present pseudo-council when they, for example, the members took a lot of money just for meeting once as the library commission. So we don't want that. But our vision goes further than this, because what I've heard today and what I've known before is that there is always a problem with the ministerial control over the judiciary. It's different in different member states. It's either the nominations or it is the money. So since we are dreaming at this point, which is a good time after lunch, let's dream about something better. We do not want the judiciary to be out of control, because it has to be controlled. And the checks and balances should work either way. But talking yesterday with my colleagues, we realized that there is no independent judiciary if it doesn't have an independent budget. Because, for example, what happens in Poland now is that we have our salaries provided for in law, in the law on the common courts. And what the politicians are doing, they are cutting the salary in the budgetary law for the third year running. So they can punish us very easily, us, you, whoever. If you're not good, we won't pay you the amount you deserve. So, poproszę slide. We thought, oh, it's not that, it's not the vision yet. Going back, just one moment, going back for just one moment to the previous thought, if the council is faulty, all the competitions have to be repeated. Because there are many cases in the Court of Human Rights already concerning the inappropriate composition of a Polish court. And it's a win-win case. The Court of Human Rights dealt with the Supreme Court, the Constitutional Court, and I think it's only the matter of time when it will deal with the common courts. Right now there is a case in the Court of Human Rights of 12 combined cases of all kinds of courts, criminal, administrative, civil, and they have one common feature. At some point of the process, there was an EU judge. So in order to eliminate the results of the work of the improperly nominated council, we have to repeat the competitions, and the people who were promoted have to go back to the spots that they had previously. And they can participate in the competitions, they can win, but they don't have to. And I think it's fair, both to the citizens and to the people who decided to participate in such competitions, despite the doubts about the council. Okay, and okay, 3 minutes to finish my vision. Our proposal, our dream is to make the council the center of judicial administration. Not the Ministry of Justice, who supervises the courts, but the council, who has this constitutional obligation to to watch over the judicial independence. So it should have a budget and it should administer the court system alongside the Supreme Court. And of course, it means professionalization, because it won't be just, meetings of the council once a month to discuss the candidates, but it will be like a full-time job for both for the judges, the other members, and they should need a lot of administrative staff. But there are many judges seconded to the Ministry of Justice at this moment. They have many clerks who deal with the court system, so it's not a problem, I think, to create a body that would deal with that in the Judicial Council. So finishing up, being at this point of our history in Poland, we are allowed to dream, and I hope that you can make our vision even better. Thank you.
Thank you very much. And now let's go directly to Michael Sjoberg and to a very optimistic, I hope, presentation. The floor is yours.
Okay, thank you. Well, I had actually 2 slides I should have liked to show you, but instead of, I have to be more, do it in a more easy way and try to explain to you what was on these slides, because the technique doesn't work, unfortunately. But the first slide was a slide of the court system of Denmark, because I would show you that we had three tiers as everyone: a Supreme Court, 2 high courts, and a lot of district courts. But what is most important there is that underneath or on top, you can put it either way, we have a judicial council. And we got that judicial council in '99. And it composes of 5 different councils, boards, you could say. And we have a court administration, and this court administration has it's an administrative organization, but on top of that we have a board. And what is similar for all these boards, that is the composition. And the composition is that we have judges' majorities in all these boards. So it means that our judicial council, which leads, in one way or another, our legal system, has a judges' majority. And we established that system in July '99. So it means that, and even the Danish Judicial Appointment Council, and that's what I will concentrate about now in my few minutes, it was established on July 1st, 1999. And that means actually that most of the Danish judges have been appointed by this appointment council, myself too. It's an independent council that handles applications for vacancies as judges, and it is judges and presidents. The only exception is the president of the Supreme Court. He or she, it's normally a he, but he is appointed by the Court of Justice among his own peers. Well, the composition of the council, and that was my other slice. That is that on top, as chairman, as president of this council, we have a Supreme Court judge, and this Supreme Court judge is elected among his peers. And the next one is that we have a High Court judge, and this High Court judge is also elected among peers. And we have a City Court judge, District Court judge, and this City Court judge is also appointed by he or her peers on the annual meeting in the Danish Association of Justice. Not Justice, but Danish Association for Justice, yes. And then we have an attorney and 2 public representatives. But what is important, that is that there's a majority of judges in these committees, in these councils. they are elected for 4 years, and they can be postponed. Well, all its activity is mentioned in the law. What is interesting is that the council can only recommend one applicant for the vacant position, and it makes its recommendation to the Minister for Justice. And the way it works is very transparent. If the council is not, if it does not agree on one candidate, then they have to explain why. And I think it works. And the minister, he can reject the recommendation and ask the council to recommend another candidate. It has never happened for 23 years. I noticed what was said about Iceland, but I think that the difference is, for instance, in Denmark, that the council can only recommend one candidate. And if the minister does not agree, and he and she has never done that before, it would be almost a revolution. Well, Monica wrote me before this event and said, well, how did you get this system in Denmark? And I've noticed that Anna Sander said it was a brilliant system. I should ask, of course, all the professors here, if we fulfill all the conditions. I think we more or less do. We have one problem with the Danish judiciary, and I think that's a problem. Dorota mentioned this as well. I think we all have that. We are not quite independent from the executive, but we have something in Denmark which we have never used, but which means that we are in a way independent of the executive. Because if the budget, if the board of the council finds out that the budget is too low, they can't work with it, then they can go to the parliament and ask for another budget out of the minister and go directly to the parliament. It has never happened. I think we should have done it this year, but I'm not sitting in the board. But anyway, we have the possibility. So I think we are almost as good as we can be. But how did we get this system? Well, Denmark is a very peaceful country. We had a kind of revolution in 1849 when we got the constitution, a kind of revolution because nobody was killed, nobody was hurt, but a lot of people were in the streets. And then we have had this constitution. It's very, very difficult to change. So all this legislation we have on these legal councils is based on ordinary law. But it's relevant to notice that it has passed by a unanimous Danish parliament. All members of parliament voted for this. We had a debate in the late 80s and the late 90s because, well, people felt, and that was right, that there was the connection between the judiciary and the Minister of Justice was too close. Well, we had no proof that the minister ever interfered, but you know, the minister was sitting on the budget and the minister appointed judges. So and that was the situation. And then on top of that, we had a huge political scandal in the middle of the 80s, and that involved the Minister of Justice. It was nothing about the judiciary, but it has something to do with the asylum system. But it involved the minister, and there was set down a committee to find out what was going on, and suddenly the government had to resign. And the problem was, next to this discussion, people said, well, the Minister of Justice has too much power. The minister and the ministry has too much power, and they have too much power on the judiciary. So therefore, there was established a committee, and this committee made a suggestion that we should have a new organization, an arm's length situation with a new court administration, and first and foremost, a Danish Judicial Appointment Council. And that was established in 1999. So, well, we had a long debate, but it was peaceful. And what is, I think, you should notice that is that it passed unanimously in the Danish Parliament. And you could tell me, does it work? Because one thing is what you have on paper, but does it work? And I must say, yes, it works. Actually, it works very good. We have had it for 23 years now. Nobody would have another system. Well, maybe you could, if you should be, if you should criticize the system a little, then you could say the appointment system works in a way that they always choose the best candidates. Well, if you ask the council, they say we always choose the best candidate. But the situation now in Denmark is, for instance, that a lot of Danish judges are among my age, and we will retire within very, very few years. And when they choose my successor, they will choose, of course, the best, probably better than me, but they will not look at his or her age. They will not look, do we need women, do we need men in this court, or what is the composition? To use another expression, they are not a human resource organization. They are a council. And that you could criticize it for that, but anyway, it's a totally independent system. Well, I could talk more, but I think the time is running, isn't it? So if we should have any debate, I think it was the shortest one we have had today. But let me just say one thing. I think people have always a feeling that, you know, the three countries or the three, or sometimes we say five, sometimes we say three, Scandinavian or Nordic countries, we are more or less alike. We have more or less the same language, the same history and things like that. But the Danish appointment council is something the other ones don't have. They have, if you ask me, a very old-fashioned system. In Norway, they have our systems, as our system was 25 years ago, and the judiciary in Sweden, they have their own problems. They are very, very close connected to the government. But so therefore, when people say, well, you in the Nordic countries, when we talk about appointment of judges, we don't have a similar system. So thank you.
Thank you so much. And actually, as far as I'm correct, in Denmark, there's the highest level of trust in the society for the judiciary. So making judiciary more independent resulted in the higher level of trust. Yes, so I think we have like 5 minutes. So yeah.
Thank you. This is only one short question of understanding to you, Michael. There were 6 members on your slide, 3 judges, Supreme Court, District Court, and High Court, and 2 members of the public, 2 representatives of the public, and 1 attorney. So 6 members, 3 judges, 1 attorney, 2 members of the public. But why you said there is a majority of judges? I counted 3 and 3. Is there a majority? I would like to understand that better.
Yes, you are right. You're right. That's because we've got 2 high court judges. Yes. But we have, and I can tell you that we had this administrative board, or the board over the court administration, and they are a little more than 6 people. But we changed the composition 2 or 3 years ago because there was not a judges majority there. But we have had it now because we put an extra president into that council. So we have judges majorities everywhere. Duro?
Thank you. I didn't want to pose a question to you because we are friends, but I just wanted to I just wanted to make a note about this sliding doors problem of judges going to the ministry and back. And there is very interesting judgment of the Czech Constitutional Court, which pronounced this possibility unconstitutional because on the principle of permanent appointment of judges. So if they are permanently appointed as judges, they cannot go in there. So this is something which should be perhaps noted.
Maybe we should, my proposal is for Dorota, because there was the question from our Spanish colleague, and whether there are some threats not actually from the politicians, but from some powerful groups like, so could you, from Polish perspective, yeah. Okay. Okay. Perfect. Okay, thank you.
My question was appropriate for the other part. But I think that for this panel is not appropriate. If you hear the situation in Turkey, if you hear the situation in Albania, Ukraine, Moldova, etc., my question is a delicatessen. When the people are living for life, are fighting in order to live, to survive. May I do? Do I explain my question?
I would like to actually comment for a moment about the checks and balances, because it's always the problem of cooperation of power. Whether because the powers are supposed to cooperate, the judiciary with the political power, but on the other hand, it has to be transparent. It's for you to reflect on how to cooperate and stay transparent and stay separate.
The main problem is that a lot of people always repeat the same idea. The public is the judge. The public is the enemy. The market is always innocent. My idea is there are guilty and innocent in the public life and in the private life. That is my idea.
Maybe one short comment from Orhan.
Yeah, this is our experience again. Interference with judiciary in at least two ways. One with the individual case by case interference. And the second is the interference with institutional structure. The government can make the judiciary open to influence of other powers. When judges do not feel themselves safe, then they can be subject to influence from other private powers. Thank you.
If I may comment? One comment, I think that when we are facing like a backsliding of the rule of law, and we are facing this increasing interference of political power in the farther perspective, the influence starts inside the judicial system, because this is what we observe, I believe, in Poland, that people who are holding administrative functions or various functions in the judicial system, they're starting to be a threat to judicial independence of other judges. So I think that this is like a further step, unfortunately, in the development, that this threat for judicial system or independence is coming from inside the system. Sorry for this comment.
So final question from Felipe, and we're going to...
Just one remark and one question. The first one is that we are, the conference that Metal organized in Lisbon in December 2021, I think. There was a very good speech by Professor András Sája from the Central European University, precisely on how to rebuild the judiciaries that were affected by illiberal democracies and attacks on the rule of law. And he, well, his speech, and then he wrote the article on the difficulty of having a restructuring of the judiciaries, which may be compatible with the European Court of Human Rights jurisprudence on irremovability. Because European Court of Human Rights has also always been very restrictive on restructuring judiciaries systematically. So he wrote a very interesting article on how to, basically his idea is it's very easy when you have a revolution, because when you have a revolution, it's clear that you need to have a total restructuring. In the case of attacks on the rule of law by liberal democracies, you have a more subtle attack on the independence of the judiciary, so it's harder to make reform compatible with the European Court of Human Rights jurisprudence that can rearrange what autocratic governments have disarranged. Fortunately, we will be publishing all the speeches by Springer, hopefully in September, October, and one of the articles of the book is the speech by Professor András Sájo. I just wanted to point that out so you can be alert that that article may be interesting for the discussion we were having in this panel. The other, this was the remark, and now the question/comment debate. We have seen, picking up on the last part we talked about in the morning, like Professor Kirchsterk said, is there a common system? No. Is that a problem? Also no. I remember 10 years ago in 2013 when we wrote a contribution of Medel to the Assises de la Justice, which was the first big event on justice that the Commission organized. We were calling for the need to have positive minimum rules for the judiciary in Europe. Some months later, we had a meeting in the European Commission with the Rule of Law Department, and they told us, please don't say that we need positive minimum rules, because that means that we still don't have positive minimum rules. So what we need to say is that we already have positive minimum rules, although they are not written. And so that's basically what the European Court, after the Portuguese judge's case, started saying, that they are not written, but they do exist. Now, and picking up now on what Professor Ansander said, is in Germany, we don't have any problems, but we don't have an institutional guarantee. And maybe in the future that may pose a problem if political circumstances change. So now, 10 years later, now that the court has already said that, shouldn't we be calling for positive minimum rules? Although it's not a problem right now, we may see in the future, we may imagine the problems that could arise if certain parties win certain governments in certain countries. Shouldn't we now be calling specifically for minimum positive written rules on the judiciary, even if it's not spreading superior councils all over, because as we have seen today, a superior council, it's not, I come from a country that has a superior council for centuries, and it has served everything, dictatorships, democracies, monarchies, republics, so it's not the existence of a council that makes the difference, it's how you use it, basically. Shouldn't we have positive minimum rules laid down in EU law? That's a question.
You address it to Kesterk on Sender or
to anyone?
To anyone. I don't know, Kes or maybe.
Well, I started my contribution by saying independence and partially the requirements, they are there. So what you said about it's already there, it's just not written down, but it's already there. That's, I think, is the justification of one of the justifications of the courts in Luxembourg and Strasbourg. What they say is what we are used to, at least in the let's say in the Western and Southern traditions in Europe about finding the law. We used to work with open criteria, and we find the law. So I find it a puzzling question, because at the moment I would say probably no, because I feel that in many countries the standards are met, and it's still not working. So I would rather invest in the people, like they do in Ukraine, so to speak. Sometimes with the help of the international community, sometimes that's not necessary, and invest in getting the right people with the right ethics. You said yourself in your country, there was a council, probably with all judges in Portugal, and it served all kinds. And we must have people there who only serve democracy under the rule of law and know what it means and how to protect it. I think that is, to invest in that is, at the moment, I think, more important. And yes, I think rules are important. The ethics of the people are important, but even more important is the support of the citizens. If you do not have the support of the citizens, the autocrats will bulldoze you. I think that is what I know the former First President Gersdorf once said in a speech. You know, I don't want to be unkind to the Polish friends, but probably what the judiciary in Poland before what this happened mistook was that they had to invest more in the relations with the public. And I would say, so I would more invest, I would not so much focus on the rules, because I think the courts are doing a rather good job in that respect. I would focus on getting the right people with the right ethics, with the right values, the right spots, and invest more in the relationship with the people. If you have the trust of the population, the politicians will not dare to attack you. You see this in the high trust countries. That is in the Dutch judiciary, we monitor the trust every 2 months. And we see it goes this a little bit like this, but it's always around 70% of the population. And I'm convinced that this is why we are not so attacked in our country, we, the judiciary, as in other countries. Although we have 20% of the vote is going to populist vote. I have no, you know, it's not very different from other countries, but this is our shield. This is our shield. This is, and that's why you must. So I would not say, so that is my answer. I would not invest my time in minimum rules, because it will take forever to establish that. And they're more or less, there. Invest in the right people and invest in the trust of the population. Absolutely.
Thank you so much, Kes. I think it's perfect conclusion for our conference. And maybe for Dorota, just few words on behalf of Justitia for the closing of our conference. Then
I am very grateful to those who survived and stayed till the end. So enjoy the rest of your afternoon, and we'll see each other at dinner tonight. Thank you.
thank you so much. And remember, at 7 p.m. there will be bus waiting in front of the hotel and taking you
to Ołtarzew, which is very difficult to pronounce.
And if you want a certificate,